Everyone else, you're here for first appearance. The purpose of this hearing is to determine whether there is probable cause for your arrest. I've already reviewed the probable cause affidavits in your case. I've already determined whether there was probable cause or not. If I found there was no probable cause, you will be released today. That does not mean that your case is dismissed. It just means the law enforcement officer did not give me what I needed in order to find probable cause, and you will need to come back to court another day. If I found probable cause, I'm then going to ask you a few questions to determine whether your bond will stay the same, increase, decrease, or whether there will be any other bond conditions imposed against you. Please only answer the questions that I'm asking you here today. They're designed not to get you into any more trouble and designed not to violate your right to remain silent. You have the right to have a lawyer represent you at each stage of these proceedings. If you cannot afford one, then I will appoint the public defender's office for you today. At this time, I'd like everyone to raise your right hand so I can place you under oath. Solemnly swear or affirm the testimony before the court be the truth, whole truth, nothing but the truth. All right, go ahead and put your hand down. As I call your name, please come forward. Asia Newbert. Can I confirm your date of birth, please?
2999.
You were here today for a violation of probation on a battery charge. It's based on a warrant that I signed on July 16th of this year. Probation is recommending 180 days for you to resolve this case today. Did you want to take care of it today?
Yes.
Okay, you want to plead to the 180? Can you hear me okay?
Yes.
Okay. Do you want to take care of this case today and be sentenced to 180 days jail, or would you like time to talk to a lawyer first?
I'd like time to talk to the lawyer.
Would you like me to appoint you a public defender?
Yes.
I'll appoint the public defender's office. Keep it at no bond. We'll see you back to court on January 6th at 9 o'clock. Crystal Nelson. Is it okay, Mr. Morris, I set you for January 14th with a waiver?
Perfect, thank you.
All right, very good. Ms. Nelson, can you confirm your date of birth?
10/11/85.
You are here today for defrauding a pawnbroker and dealing in stolen property. Your bond amounts are $7,000. There is probable cause for your arrest. I do see you have an open case right now, 2019 CF 1687 in front of Judge Toner, set for December 16th. We're going to make sure that this case tracks with that, okay? And state, I couldn't tell whether this was the date of offense jived with an RCO or not.
So yes, Your Honor, it would meet an RCO because she was arrested originally on this on August 29, 2019 and bonded out on September 8, 2019. She went on PTI and she was non-compliant and rejected from the program on May 1st, 2020. She had no contact with the PTI program. And this date of offense was in September. So the state would ask.
So she just kind of absconded from the PTI?
Yes, Your Honor.
Okay. All right. I have an address here in Garfield Ave in Zerricktown. Is that where you live?
Yes, ma'am.
How long have you lived there?
4 months.
All right. How long have you lived in Hernando County?
Most of my life, 20 years.
Okay. All right, well, here's the deal. You have that pending case. You kind of didn't do what you were supposed to do, and instead you picked up these new crimes. So I'm going to recommit you on the 2019 CF 1687 case. That means you're going to be held in custody until you resolve that case. You're entitled to bond on these new cases. I'll keep the bond at $2,000 and $5,000, and we will see you back to court on December 16th at 3:30. Sorry.
Ma'am, can I mention one thing?
Sure.
I'm supposed to be in the hospital. I have osteomyelitis in my spinal cord on antibiotics. I signed out the other day, but I'm in a lot of pain and I need to get there because I'm septic.
Okay. I'm sorry, ma'am. That's just the way it's going to be right now. You can talk to the nurse and the medical there at the jail, see if there's anything that they can do for you to make you a little bit more comfortable, and then you can talk to your public defender about getting in front of the judge and what's going to happen, okay?
Okay.
Thank you. Robin Roosh. Can I confirm your date of birth?
126/72.
All right, Ms. Roosh. You are here today for a DUI. There's probable cause for your arrest. Do you want the public defender's office to represent you?
At this time, yes.
Okay. I'll appoint the public defender's office. I do see where she's got a 2010 DUI. Is there anything else on her record?
A fraud, obtained controlled substance, and 2 counts of that in 2009 with a withhold of adjudication, and then a reckless driving no disposition in 1996.
All right. Ma'am, I have an address for you on 41 in Spring Hill. Is that where you live?
No, ma'am. I live on Drive Street.
Okay. How long have you lived there?
Approximately a year.
Okay. Do you have a job?
No, ma'am. I'm on disability.
Okay. All right, I'm going to keep your bond at $1,000. I'm going to see you back to court January 6th at 9 o'clock, okay?
Okay.
Thanks. Danielle Walker. Can I confirm your date of birth?
11/8/92.
All right. You are here today for a grand theft auto. Your bond amount is $2,000. There's probable cause for your arrest. Do you want the public defender's office to represent you?
Yes, please.
Okay, I'll appoint the public defender's office. Any criminal history?
No, Your Honor.
Okay. I have an address for you on Sandusky Street in Brooksville. Is that where you live?
Yes.
How long have you lived there?
The last 3 months.
Okay. How long have you lived in Hernando County?
All my life, but I recently just moved up.
Okay. Do you have a job?
No.
Okay. All right, I'm going to set your bond at $100, and we're going to see you back to court January 5th at 9 o'clock, okay?
Okay, thank you, ma'am.
Nisha Bearcat? Can I confirm your date of birth?
1/26/76.
Okay, you are here today for a domestic battery. There is probable cause for your arrest. Do you want the public defender's office, or do you want to hire a lawyer?
Can I speak?
In a moment, I'll get to you. I know you're here, and I know you want to speak. I'll call you up when I'm ready. I'm waiting for her to answer my question. Can you hear me okay?
Yeah.
Okay, would you like me to appoint you a lawyer? Okay. Are you working right now, ma'am?
No.
Not working? Okay. I'll go ahead and provisionally appoint the public defender. I'm going to give you a lawyer, okay? If for some reason you hire a lawyer later, you can do that, and the public defender's office will withdraw from your case. Okay?
Okay.
All right. Any criminal history?
No, Your Honor.
Okay. I have an address for you on Firethorn Point in Spring Hill. Is that where you live? What? Where's she going? How long have you lived on Firethorn Point?
Like 23-year-old.
Okay, lots of years. Okay. And then the victim in your case is here, Mamand, and he would like to say something. So if you can, I want you to stay at the podium for a little while longer because I still need to give you a court date and everything else. So I'll let you know when it's time to sit down, okay? So, Mr. Borghi, you can come up and I will hear what you have to say. Wait. Come up here.
Come up to the podium, sir.
She has the right to hear what you have to say. I need you to raise your right hand for me. Tell me, swear or affirm this testimony before the court will be the truth, whole truth, nothing but the truth.
I swear.
Okay, and your name?
Mahmoud Bagri.
Okay, what would you like me to know?
She has a delusional disorder and she is not taking her medicine. The whole purpose of the call yesterday was to help her to get to the hospital. I have children at home and the DCF already at home. She has nothing in medicine for a week now, and being in jail will not help. She needs to be treated. She does not even speak good English.
Okay. All right, so...
Her doctor at Springbrook, her psychiatrist, he knows her for 5 years, and he is ready to help her today.
Okay.
I'm a physician myself.
So the only thing I really need to determine today is her bond amount, which I think I know what I'm going to do with that. But as far as your contact with her, typically speaking, the statute requires me to order no contact between the defendant and the victim when there's an arrest like this, until the case is resolved or until there's some type of motion allowing contact. So that would mean that she would have to live somewhere else while this case is pending. So how do you?
Yeah, we have a place for her. She has a friend.
So do you want to make sure that she has no contact with you right now?
Yeah. Mhm.
Okay, so we're going to go ahead and order the no contact. Now, do you think that
I do not want no contact. If you see what I mean, if you can waive that, because she's delusional.
Okay, well, that's why I just asked you, but does she
she's-
need an interpreter?
She does. Yeah, most
Okay.
of what you said, she
For,
didn't understand.
for what?
Arabic.
Arabic? Okay.
speaker. I mean, she was acting on her delusions. I mean, she didn't mean to hit me.
Okay, so are you going to feel safe in the home if I
Yes.
allow her to go back home?
Yes.
And there's no threat that she's going to hurt you or your children or
No.
anything like that? Okay. And you're going to make sure that then she gets whatever treatment she needs to
Yeah.
get in order to make sure something like this doesn't happen
Right.
anymore? Okay. So I will go ahead and allow peaceful contact between her and you. So anything that can be deemed not peaceful would be a violation of my order. So it'd be peaceful contact, okay?
Okay.
And then usually I have to hold, again pursuant to statute, I have to hold her in jail until 4 o'clock to give the alleged victim an opportunity to file civil paperwork or an injunction, restraining order against the defendant. Is that something that you are looking at doing today?
I can do it if I have to. I mean, I really want her. I'm ready to take
It's not
her to the
have
hospital.
to. That would mean that you want to file an injunction against her, requiring her to have no contact and not be within 5 feet of your house and things like that. Are you going to be doing that today? If you're not going to do that, I can allow her to get out of jail sooner.
Yeah, I don't want to do that. Right?
Okay. So I can't let her out of jail without a bond, again, pursuant to statute. So I have to set the bond. I'm going to set it at $100.
Okay.
Ma'am, you're going to have a $100 bond. And if you want to go down to the jail and bond her out, and her court date is January 6th at 9 o'clock, and we'll make sure to have an interpreter here for her for that
Okay.
hearing, okay?
All right.
All right. All right, thank you. Frida Ross? Do you guys note somewhere on the dispo or somewhere that we need an interpreter for her, so we don't forget at the hearing? I don't know where to make a note of that. All right, can I confirm your date of birth?
4/18/70.
All right. You are here today for a DUI manslaughter, leaving the scene of an accident, a DUI, and then it looks like 2 counts of DUI property damage. There is probable cause for each of these. Do you want the public defender to represent you, or are you going to hire somebody?
Yes, please, the public defender.
Okay, I'll appoint the public defender. And I was a little confused with the bond amounts. They had $5,000 for the manslaughter, but no bond on the DUI property damage. Is there a rhyme or reason? I couldn't figure it out.
Your Honor,
Oh, hold on, I'm not talking to you.
Melissa Underwood for the state, and I did not see a reason for that specific finding. I would note that the $5,000 bond on the DUI manslaughter is below the bond schedule. But I'll leave
But
that.
then the no bonds were above, so.
Exactly, so it kind of balances out.
Messy. All right, so is the state asking for anything specific that we don't normally do, or?
No, Your Honor, the normal run of what we do, and she does not have any prior record.
Okay. I didn't even get a driving record. Does she have a driver's license?
I believe so. Your Honor, I do have a driver's license number on the.
Okay. All right, I just usually when I don't get one, it means they don't have a Florida one. So she does have a Florida driver's license?
I can
Okay,
get that.
that's okay. That's all right. Yeah, there's nothing really on it, right?
Not that I'm aware of, but there's nothing on her criminal history. So I
Okay.
didn't run a driving record.
Okay. All right, ma'am, I have an address for you on Springtime Street in Spring Hill. Is that where you live?
Yes, ma'am.
How long have you lived there?
13 years.
All right. And do you have a job?
We quit working at the beginning of March when the COVID hit, so we've been retired.
What kind of work did you do?
Cell phone towers.
Cell phone towers, okay. All right, I'm just gonna fix the bonds. Was the scheduled bond on the manslaughter, I think, was it, 10,000?
Your Honor, I showed that it's 30,000.
30,000?
Yes,
Okay.
Your Honor.
And then the DUI property damage would just still be 1,000. So you have no prior record, you lived in the community a long time, so I'm going to go ahead and set your bond amounts at $5,000 for count one, it'll be $5,000 for count two, and then $500 for count three, $500 for count four, $500 for count five, so it's a total of $11,500. The bond amounts are not reflective of the seriousness of the crime, and the reason your bond amounts, what some people may consider as low, is because you don't have a job right now and because you don't have a prior record. So I think those bond amounts are fair. I've appointed you a public defender, and we'll see you back to court January 5th at 9 o'clock, okay?
Yes, ma'am.
All right.
Thank you, Your Honor.
All right.
That concludes my business.
Have a good day.
Thank you, you too.
Paul Shank.
One moment, Your Honor.
Oh, okay. I can pass him and move on to someone else if you need me to.
Yeah, if you would just take
Okay.
one more, Your Honor.
All right, no problem.
It's a bit of a problem with everything.
Okay, no problem, I understand. John Paul. John Michael Paul. Good morning, sir. Can I have your date of birth?
10/7/74.
All right, you are here today for contempt of child support. There's a writ of bodily attachment saying that you owe a lot of money, and they're looking for $694 for a purge amount in order to get you out of jail. Are you going to be able to scratch that up?
There is no way.
No way? Okay, well, let's see what's going on here. When was the last time you had a job?
March.
Okay, I'm looking at an order here from February 18th, 2020 from Judge Eidemann. At that time, he found that you had the ability to pay, so what happened?
From when?
February of this year. Oh, that's the writ. Okay, so the order of contempt was from, February 19th, 2020, that you had the ability to pay, and that you haven't been paying.
Okay, I thought I had paid.
So they said that you were in court November 7th, 2019, that you had the ability to pay, and you were ordered to pay $624 by November 22nd, and it was never paid.
Okay.
And that was based on the finding that at that time you had employment and you had the ability to pay. So you said you haven't worked since March. So what happened in November, December, January, and February where you didn't pay the $624 and you violated the judge's order?
I was working at the casino for a friend of mine. It was off the books.
Okay.
And I guess it just slipped.
Well, it doesn't say anything in here like if he's working off the books, he doesn't have to pay his child support. I don't see
Oh,
that
yeah, I
anywhere.
understand it. I
Okay.
understand it.
So why haven't you worked since March?
Because the restaurant closed down.
Okay, but some restaurants didn't. How many jobs have you applied for?
I was going to go back there. I went back in April, and then she decided to close down again. And I moved in a roommate and just went from there.
All right, so how do you afford your rent every month?
My dad and my sister owns my house. My roommate pays the electricity and the water, and I have food stamps, the Obama phone, and that's really all I needed.
Okay, well now we gotta talk about what your kids need, don't we? It's not about what you need, it's about what your kids need. So you have the ability to work, and you just have chosen not to, as it sounds like to me.
I have applied, just haven't got anything back.
I don't know if I believe that, sir. I think you found yourself in a position that you have exactly what you need, and you're living off your family and whatever else you got, and you have found a convenient way for yourself not to have to do what you've been ordered to do since November of 2019. You worked off the tables, you kept the money to yourself, you made sure that because it wasn't on the books, they weren't able to garnish your wages, and you found a way to get out of paying anything. So now you're going to be held in jail until you do 30 days jail or pay the $694.
Cardio.
Okay?
All right.
Thank you.
Okay.
Cardio.
Are we ready with Paul Shank? All right, can I confirm your date of birth?
4/29/83.
You are here today for a petty theft. There is probable cause for your arrest. It's a felony petty theft. Do you want the public defender's office to represent you, sir?
Yes.
Okay, I'll appoint the public defender's office. Is there anything I need to know?
Yes, Your Honor. He has an open felon possession of a firearm and a driving with license suspended and tampering with physical evidence from June of 2020 in Pinellas County. He has a petty theft and a trespassing adjudication in November of 2020 at Willis that's open in Pinellas County. He also has a paraphernalia adjudication in April 2020, a felony petty theft in October of 2019, felon carrying a concealed weapon and a possession of hydromorphone adjudication 2019, petty theft second degree, third subsequent offense adjudication in 2019, possession of controlled substance, petty theft second offense, possession of controlled substance, medical drug without a prescription, a resisting without violence and a false name adjudication in 2018, a grand theft and a possession of controlled substance adjudication in 2017, a duelist third, and a hit and run adjudication in 17, leaving scene of the accident it was, a felony drug possession adjudication in 2015, a marijuana less than 20 adjudication in 2015, a duelist adjudication in 2015, a disorderly conduct withhold in 12, a felony duelist adjudication withheld in 10, and then he has several driving with license suspended that go back to 2003.
Okay. All right, Mr. Shank, I have an address for you on Trumbull Drive in Spring Hill. Is that where you live?
Yeah.
How long have you lived there?
About a year, 2.5 years.
Okay. Do you have a job?
Yes, ma'am.
What kind of work do you do?
Spray material, draw texture.
Okay. All right. I'm going to set your bond at $10,000. We'll see you back January 5th at 9 o'clock, okay?
Thank you.
All right. Brian McCormick. Can I have your date of birth?
10/14/1988.
All right, you are here today for dealing in stolen property and unlawful use of a two-way communication device. Your bonds are currently $15,000. I found probable cause for your arrest. Do you want the public defender's office to represent you?
Yes, ma'am.
All right, I'll appoint the public defender's office. Criminal history?
Duelist 2 or more priors adjudication in 2017, a duelist second offense adjudication 2015, a dealing in stolen property adjudication in 2015, a duelist adjudication in 2015, a petty theft possession of cannabis less than 20, and a paraphernalia adjudication in 2014, controlled substance and paraphernalia adjudication in 2013, a trespass adjudication in 2013, controlled substance and paraphernalia adjudication in 2012, a battery adjudication in 2012, grand theft adjudication in 2011, a duelist adjudication in 2011, a resisting without adjudication in 2011, a marijuana with intent to sell adjudication in 08, a possession of cocaine adjudication in 08, and then delinquency.
All right, I'm going to address you on Evening Star Ave in Brooksville. Is that where you live?
Yes, ma'am.
How long have you lived there?
About 14 years?
Okay, do you have a job?
No, ma'am.
Okay. Bond amounts are 10,000 and 5,000. We'll see you back January 5th at 9 o'clock, okay?
Ma'am,
Yes?
is there any way possible I can get the bond lowered?
No.
Okay, thank you.
Jacob Jericho?
Will you send me? Yes, ma'am.
Can I have your date of birth?
April 17, born in 1990.
Okay. You were just in my courtroom yesterday, right?
Yes, ma'am.
All right, and I guess you have this outstanding child support enforcement.
Can I say something, ma'am?
Sure.
My rights, I went to trial for my kids and my rights got terminated. I have no rights to my kids at all. I'm not even allowed to see them or talk to them. So I went and signed my rights over to Chloe Ryan and Emma. It's hard enough for me not to see them. It's kind of really touching that I'm being arrested for it. But I miss my kids. And I got a job. I work through day labor. I want to see my kids, but I can't see them. For me, I have no parental rights. I don't even understand why. Like, I'm getting punished twice. I don't even get to see them, man.
Okay.
And I got no rights. Nothing. I don't even get to say hi, see them. Not Zoom, nothing.
Okay. Well, listen, I wasn't there for that hearing. I don't know what happened, and I don't know why you lost your rights to your kids, but that's not at issue here today. And I don't mean to sound unsympathetic, but what we're here for today and why you are in orange right now is because you owe $18,506.22. That may be from before you lost your parental rights, but that is what you owe. That is what you will continue to owe your children. And if you want to try to do right by your children from this day forward, moving forward, then you will pay what the court says that you owe to help them. So you may not ever have contact with your children again, but that doesn't mean that you can't do what's right. So you owe over $18,000.
I didn't know I still had to pay, ma'am. Is there any way that I can go to my job today? Because I have work today, and I can go to work today. I can start paying something today. If you can let OOR me so I can go to work. And I didn't know I was supposed to pay. I'm sorry for that.
All right, and how much money can you come up with in order to get out of jail? I'm not going to be able to ROR you to pay. You have to come up with something to get out of jail.
The only thing I can come up with today is $50. That's it. I mean, after that, I start paying. I swear to God. I just didn't know.
Is your current address on Coombe Road?
Yes, ma'am.
And your phone number ends with 6986?
Yes, ma'am.
All right, you have to pay $50 in order to get out of today, or you're going to do 10 days jail.
Yes, ma'am.
And if you don't make payments, this is just going to keep happening over and over, okay?
Okay. Yes, ma'am.
All right, thank you. Jesse Prindle? Can I have your date of birth?
11/20/1994.
All right, you are here today for a battery charge. Your bond amount is $1,000. There's probable cause for your arrest. Do you want the public defender's office?
Yes, ma'am.
I'll appoint the public defender. And criminal history.
He has open possession of a firearm by a convicted felon, and possession of ammunition by a convicted felon, as well as carrying concealed weapon in Orange County from September of 2020. He has a resisting officer without violence adjudication in January of 2020, where he spent 60 days in jail. A Willis adjudication in 2015. A Berg of a structure adjudication in 2014. A Berg of a structure adjudication in 2014, as well as a charge of Berg while armed in 2014. A petty theft adjudication in 2013. 2 counts of that. And then he also had a delinquency aggravated battery in his history, no other history, Your Honor.
Okay, Mr. Prindle, I have an address here on Coleman Lane in Brooksville. Is that where you live?
Yes, ma'am.
How long have you lived there?
About 2 weeks. I just came back to Hernando County recently.
From where?
Luke, Florida.
Okay. You have a job?
No, ma'am.
Okay. I'm going to set your bond at $5,000. You need to have no contact with the victim, Ashley Berry. Don't have any contact with her whatsoever. And we'll see you back to court January 6th at 9 a.m.
Okay,
Thank you. Pierre Langley. Can I have your date of birth?
10/46, 1990,
You're here today for a trespass at Coney Island. So is this one where we can take care of it today? Or?
Yeah, an adjudication 1 day, time served.
Okay. So what the state is saying is that if you want to take care of it today, they'll give you 1 day in jail, give you credit for the 1 day that you already have in. You will just owe fines and court costs of $550. Is that something you'd like to take care of today?
So you saying it was just a misdemeanor and I have court fees to pay after I stay a day in jail?
Yes, sir. And you can make those payment arrangements. You can make monthly payments if that works out, and you can make those arrangements to the clerk of court. You want to do that?
So, yes, ma'am. So once I get this money, you know what I'm saying, because I got this job in Louisiana coming up next year, and I'll pay $2,500 off the rip. Plus my settlement money, you know, I mean my Social Security money next month. I'll put some on there, you know what I mean?
I don't really care how you make your payments. You can make them any way you want. I just want to know if you want to take care of it today, or do you want to come back to court another day?
No, Judge, let's do this today.
Alrighty. Do you understand that by taking care of this case today, that you're giving up your right to go to trial?
Well, wait. Yes, ma'am, I'm giving my right up to go to trial.
Okay. Do you have
I don't want to do nothing but stay a day in jail and just get out.
Then you need to let me ask my question so we can get this on the way, okay? The faster this goes, the sooner you get out of jail. Got it?
Yes, ma'am.
Then just answer my questions. Do you understand you're giving up your right to confront the witnesses against you, call witnesses on your own behalf, and you're giving up your right to have the state prove the case against you? Do you want to give up those rights in order to take care of this case today?
Yes, ma'am.
With regard to this trespass charge, how do you plead? You can plead no contest. If you plead no contest, it just means that you're taking a plea in your own best interest, and you can't contest the evidence against you. Would you like to plead no contest?
No, I know I was guilty. The dude told me he had a trespassing.
Alrighty. I'll accept your plea of guilty, adjudicate you guilty, sentence you to 1 day in the Hernando County Jail, give you credit for the 1 day that you have in. You will have fines and court costs of $550, and you can make payment arrangements at the clerk of court, and then you have the cost of incarceration for your 1 day, okay?
Yes, ma'am. I got you, don't worry. I'll be there.
I'm not worried. Okay. Brian Neal? I look worried?
Super worried.
All right. Can I confirm your date of birth?
10/30/93.
All right. See what's going on here. You are here today for an aggravated assault with a deadly weapon, 2 counts of that, and a 3rd count of criminal mischief. It's based on a warrant signed by Judge Merritt on December 8th, when it looks like you failed to appear for court. Judge Merritt has indicated on here that you score out to 20 months Department of Corrections, and that your public defender that you already have in this case requested a competency evaluation, and then you kind of absconded and didn't show up for anything after that. So because of that, Judge Merritt would like me to hold you without bond until we can get you back in front of him on January 5th at 9 o'clock. I see you've already been appointed the public defender, so someone should reach out to you soon, okay?
Okay.
All right. William Isolde? Can I confirm your date of birth?
February 1st, 1999.
All right, you are here today for aggravated stalking and unlawful access of computer network. So there is, based on a warrant out, or based on Yeah, based on a warrant out of Polk County. Is that where you're from?
No, I'm from Springfield, not Polk.
Oh, you are? Okay. So they want you held, no bond on the aggravated stalking and $1,000 on the unlawful access of computer network. I'm assuming the aggravated stalking is something domestic related, and that's why it's no bond. But it doesn't, oh, it's aggravated stalking of a minor. That's why. Okay, so we're gonna see if we can get you out of Polk County. When you get to Polk County, are you going to want the public defender, or are you gonna hire a lawyer?
Public defender.
All right. I'll indicate on this paperwork here that I'm filling out that you want the public defender's office. We'll see if there's any way we can get in touch with Polk County, see if we can get you over there. If we can't get you over there, then we'll bring you back in front of the judge at first appearance and see if there's anything we can do about this bond amount, okay?
All right.
All right, thank you. Jose Reyes?
Morning, Your Honor.
Good morning. Can I have your date of birth?
4764.
Did you say 417?
4764.
Okay. So we have 417 on here. All right, looks like you have a warrant out of Broward County for a violation of probation for the original charge of refusing to submit to a blood test. It must have been for a DUI. Does that sound right?
Yes, ma'am.
Okay. Were you on probation?
Yes, ma'am.
That's right, okay, so that's why it's no bond. Okay, so we're gonna see if we can get you over to Broward County. When you get over to Broward County, are you going to want the public defender?
Yes, ma'am.
All right, I'll indicate that on here. We'll see if there's any way that we can get you over to Broward County. If for some reason we can't, because maybe they're not accepting inmates, I'm not sure what's going on, then we'll bring you back in front of the first appearance judge and we'll see if there's anything we can do about this bond amount, okay?
How much time can you hold me if Broward County doesn't come and pick me up?
Honestly, I don't think there's a limit. I mean, you're held no bond on your violation of probation. Usually they come get you within a week. So if they don't come get you within a week, they'll bring you back in front of the first appearance judge. Okay?
Okay.
Scott Hartman? Can I confirm your date of birth?
February 18th, 1967.
Okay. Has the state reviewed the PC affidavit?
Just briefly now, Your Honor.
Okay, so Mr. Hartman is in custody at the jail. The allegation is that he attempted to hit one of the deputies there at the jail. Apparently he swung and missed.
Okay.
So you see it's an open case right now. What is that for?
The open case out of,
In front of Judge Toner?
oh, okay. For some reason it
I don't-
didn't pull up in my,
It's a 2005 case. I'm assuming it's for a
Oh.
violation of probation, maybe?
yeah, so that's, the only case that I have is that all those counts, but I have it on a, yeah, I don't know anything about it, but all I know is that it's saying, that the case is open,
Your Honor.
reopened.
Hold on.
Sorry to interrupt, but
Yeah, go ahead.
she is on appeal from DOC.
Okay, I got you. Okay, so with regard to this, I'm just not, it's maybe an assault or an attempted battery. I don't know really what the difference is. Is there, okay,
I guess what,
you just need to look into this.
I'll make a note on there for that, Your
Okay.
Honor.
I don't know if there's just, if it's just not, just information not in the probable cause affidavit that I need or what,
Mhm.
but, I mean, it doesn't really matter, it's not doesn't sound like he's going anywhere anyway, so I'll go ahead and set a bond on it. It doesn't make any sense to, Mr. Harmon, I set a bond on this, it doesn't really make any sense for you to bond out on it, so I don't.
That's true, Your Honor.
So my job here doesn't have any meaning. So I'll just go ahead and set a $100 bond. And we're gonna see you back on January 5th at 9 o'clock for this case, and we're gonna see if there's anything that we can do in the meantime, okay?
Yes, ma'am.
Yeah. Mr. Hartman, you wanted the public defender on this case, yeah?
Before you appoint a public defender, I'd like to exercise my right to a speedy trial.
There is no right at this point.
Okay. Okay, that'll be noted for the record, but we don't have a right to a speedy trial right now because of the COVID crisis and our inability to have jurors. So did you want the public defender or not?
Yes, ma'am.
Okay, I'll appoint the public defender's office and we'll see you back to court in January. Ronrico Daniels. Can I confirm your date of birth?
11/20/82.
You are here today for some things you got going on in Hillsborough County. You have an aggravated battery on a pregnant person, tampering with a witness victim, and there's also a writ of bodily attachment for failure to pay child support in the amount of $3,000. So when you get to Hillsborough County, are you going to want the public defender or are you going to hire somebody?
Public defender.
Okay. I'll go ahead and note that on here, that you're requesting the public defender. We'll see if there's any way we can get you to Hillsborough County. If not, we'll bring you back in front of the first appearance judge and we will figure out what's going on, okay? So we have a $3,000 purge on the child support issue, and then your bonds on the aggravated battery on a pregnant person, 0 bond, and the tampering with the victim is $2,000, and we are going to keep that the same for right now and see if we can get you over to Hillsborough County, okay?
Okay.
All right. Did I get everyone at the jail?
Yes, Your Honor, thank you.
Okay. Good morning, everyone. My name is Judge Healis. You're here today for first appearance. The purpose of this hearing is to inform you of the charges against you and determine whether there is probable cause for your arrest. I've already reviewed all of the probable cause affidavits in your case, and I've already determined whether there was probable cause to arrest you or not. If I found there was no probable cause, you will be released today. That does not mean that your case is dismissed. It just means the law enforcement officer did not give me what I needed in order to find probable cause, and you will need to come back to court another day. If I found probable cause, I will then ask you some questions to determine whether your bond will stay the same, increase, decrease, or whether there will be any other bond conditions imposed against you. Please only answer the questions that I'm asking you here today. They are designed not to get you into any more trouble and designed not to violate your right to remain silent. You have the right to have a lawyer represent you at each stage of these proceedings. If you cannot afford to hire one, I will appoint the public defender's office for you today. At this time, I'd like everyone to raise your right hand so I can place you under oath. Solemnly swear or affirm the testimony before the court will be the truth, whole truth, nothing but the truth. All right, go ahead and put your hands down. As I call your name, please come forward to the podium. Aliana Santos. Good morning. Can you confirm your date of birth?
4/1989.
All right. You are here today for 3 separate cases of violation of probation. There is probable cause for your arrest, and it's based on warrants signed by Judge Toner on December 4th. He wants you held no bond until you appear back in front of him on January 11th at 1:30. Do you want the public defender to represent you in each of these cases?
Yes.
Okay, I'll appoint the public defender's office and we'll see you back to court then, okay? Austin Roberts. Can I have your date of birth?
12/30/92.
You've got several things going on here in Pasco County.
Yeah.
And you failed to appear on a lot of these cases. So they have bond amounts
Yeah.
on these. Are you going to be able to bond out on these?
I'm sorry.
They have bond amounts listed for these cases. Are you going to be able to bond out?
At the amount that the bond is at, no ma'am.
Okay.
I was incarcerated in prison in Ohio. and that's why I failed to appear because I was in prison in Ohio, and I've done the straight and narrow for 8 months and done what I was supposed to do.
Okay.
And they offered me an interstate compact so I could come down here and be with my child and my family. And when I got here, I knew I was coming to face these cases, and I got to do what I got to do.
Okay. All right, well, they have, just so you're aware, the charges are a battery, a possession of marijuana, possession of paraphernalia, a violation of pretrial release conditions for domestic violence. It looks like there's 2 of those. So what I'm going to do is I'm going to leave the bond the same. We're going to see if we can get you over to Pasco County. And if for some reason we can't, we'll see if there's a way we can take care of your case here without having you transferred. So right now your bond amounts are going to be $10,013, $513, $253, $5,013, and $5,013. Okay, so just over $20,700 it looks like. All right, so if we can get you over to Pasco County, we'll get you over there soon. If for some reason they can't, the folks there at the jail will let us know. We'll bring you back up and see if there's anything else we can do, okay?
Yes, ma'am.
All right, thank you. Dwayne Braxton. Can I have your date of birth?
03/23/1963.
All right, you are here today for domestic battery and resisting an officer without violence. There's probable cause for your arrest. Do you want the public defender's office to represent you?
Yes, can I say one thing? If you give me your, I can't buy myself out because I have no family or no friends here to do that. I have a job that I have.
Okay, well, hold on, we'll get there. Hold on 1 second. Does he have any criminal history?
A petty theft adjudication in 2016.
Hold on 1 second, sir, I'm listening. Okay, listen to the state attorney, he's speaking. Petty theft, go ahead.
Yes, a duelist adjudication 07, a battery adjudication in 02, a battery adjudication in 2001, disturbing peace adjudication withheld in 2000, null cross battery in 2000, drug battery in 1999, a resisting without violence adjudication in 2000.
I had all this.
That's what it's
You have the
showing.
right person.
I mean, I don't know. You can talk to your attorney about that when you get to talk to your lawyer, okay? All right, I have an address here on Broad Street in Brooksville. Is that where you live?
Yes.
How long have you lived there?
3 years.
All right. Do you have a job?
Yes.
What kind of
I'm
work do
gonna
you
lose that.
What kind of work do you do?
Landscape for sunshine.
Okay. All right, I need to order that you have no contact with Jerry Keown. Don't have any contact with her whatsoever. Do not call, do not write, do not email. Do not have anyone else call, write, or email. Don't go within 500 feet of the residence, employment, school, or vehicle. No text messaging or social media or technological contact whatsoever with Jerry. Do you understand?
Okay.
All right, if you have any,
Can I ask you
if you have any contact with Jerry while this case is pending, you could be charged with another crime and held without bond, okay?
All right, is it possible that when there's time to like get my clothes or my food card
You can-
and stuff, I can call you guys first, right? I can call the police department?
Sir, you can go to the residence one time with a law enforcement escort, and you will have about 5 minutes to collect your belongings, okay?
Okay, thank you. I'm just nervous, I'm sorry.
All right, we're going to set your bond at $500 each, and we're going to see you back to court on January 5th at 9 o'clock, okay? All right, thank
So
you.
that means, am I staying here still?
Kyle Head,
Where are you?
can I have your date of birth?
10/10/91.
You are here today for a trespass and a misdemeanor and a felony criminal mischief. It looks like you were supposed to be in court on August 13th, 2018 in front of Judge Toner, and he signed that warrant back then. So there's probable cause for your arrest. Do you want the public defender's office to represent you?
Yes, ma'am, Your Honor.
All right, I'll appoint the public defender's
May
office.
I say something?
Sure.
The only reason I did not appear in court on that charge is because
Sir, please don't admit that you did. This is a public defender. Don't admit that you didn't appear. That's a necessary part of the case they have to prove.
Does he have a criminal history?
Yes, ma'am.
Yes, Your Honor. I'm showing an adjudication in 2018 for a bird, an adjudication withheld in 2017 for possession of controlled substance, a 2017 resisting without violence adjudication, a 2013 battery adjudication, an adjudication in 2013 for a petty theft, an adjudication in 2013 for grand theft. A PTI grand theft is in 2012, and no other history.
Okay, it looks like Mr. Head was in custody in Alabama for a while, and that's possibly why he didn't appear for this. So, nevertheless, I need to get you in front of Judge Toner so you can take care of this, okay? So your court date is January 11th at 1:30. I think he's entitled to a bond. FDA's right now, you're no bond. I'm going to set your bond at $5,000 each. I'm going to see you back to court on January 11th at 1:30.
Yes, ma'am. Thank you very much.
Thank you. Benjamin Marley? Can I have your date of birth?
5692.
You were here today for a domestic battery. There's probable cause for your arrest. Do you want the public defender's office to represent you?
No, ma'am.
You're going to represent yourself, or are you going to hire somebody?
No, I'm just gonna represent myself, that's fine.
Okay, criminal history?
I'm only showing an out-of-state larceny under 250 and a trespass in 2009 with no disposition, and then a 2001 dangerous weapon with no disposition. No other history, Your Honor. It's out of Massachusetts.
Okay. I have an address for you on Copperfield Road in Spring Hill. Is that where you live?
Copperfield, yes.
How long have you lived there?
Usually since June, July.
Okay. How long have you lived in Hernando County?
In Hernando, since I moved down here in 2011.
Okay. Do you have a job?
Yes.
What kind of work do you do?
Remodel pools.
Okay. All right, I need to order that you have no contact with Christina Urich. If you have any contact with her whatsoever, do not call, do not write, do not email, do not go within 500 feet of a residence, employment, school, or vehicle. No social media or technological contact with her whatsoever. If you have any contact with her, whether through first person or third person, then you could be charged with another crime and held without bond. Do you understand that?
Yes,
So
ma'am.
you can't relay any messages to her either, got it?
Yes, ma'am.
All right, I need to hold you until 4 o'clock in case she wants to file any civil paperwork against you. After that, you can bond out for the $1,000, and we'll see you back to court on January 6th at 9 o'clock.
Okay, thank you.
Farron Porter?
Good morning, Your Honor.
Good morning, can I have your date of birth?
7/10/99.
You are here today for a domestic battery. There's probable cause for your arrest. Do you want the public defender's office to represent you?
Yes.
Okay, I'll appoint the public defender's office. And does he have a criminal history?
He had PTI in 2019 for improper exhibition of a firearm. No other history, Your Honor.
I have an address for you on Candlelight Boulevard in Brooksville. Is that where you live?
Yes, right now.
How long have you lived there?
I've lived there for 3 years.
Okay. Do you have a job?
Yes.
Okay. I have another address on Michigan Ave.
That is my mother's address?
Okay. That's probably where you're going to be going
Yes.
to get out. Very good. I need to make sure you have no contact with Jenna Fournier. Don't have any contact
Yes.
with her whatsoever. Do not call, do not write, do not email, do not go within 500 feet of her residence, school, employment, or vehicle. No social media or technological contact whatsoever. And no third-party contact. You can't relate any messages to her. I need to hold you until 4 o'clock today in case she wants to file any civil paperwork against you. And then after that, you can bond out for $500. We'll see you back in court January 6th at 9 o'clock.
Sure, thank you.
Thanks. David Elster. Can I have your date of birth?
10/29/1962.
Okay, you are here today for battery on a law enforcement officer. There is probable cause for your arrest. Do you want the public defender's office to represent you, sir?
Yes, ma'am.
All right, I'll appoint the public defender's office. I know he's got a couple things going on, but.
He does, Your Honor.
Okay.
He's currently out on a conditional release due to incompetency. We would ask for his bond either to remain as is, or actually, I would request that you RCO him on his case that he's released on. I'm not sure if the court would do that.
I'm not going to do that. Especially based on the facts of this and based on everything else, I'm not going to do that.
Your Honor, the only other thing that I would request is that there be an order ensured that he cannot return to the location where this occurred. This occurred at a nursing home facility.
I understand where it occurred.
I'm sorry?
I understand where it occurred.
And
Go ahead.
I was just going to say, Your Honor, I just got off the phone with the facility prior to coming down here. They absolutely are terrified of him returning back there.
Okay. Is that not where all of his belongings are?
They are, and they don't have an issue with him getting his belongings.
But that would involve him returning there.
Well, Your Honor, with law enforcement to get his belongings is one thing. To go back and residing there is a completely different situation.
That's a contractual thing between them and him, right?
It is, and they've actually filed or are filing the eviction to remove him from there.
Okay, well, that's something different. Go ahead.
Judge, I was just gonna say that this incident didn't involve anybody that lived there or anything like that. If they wanna try to evict them, that's a procedure that they need to go through.
Okay. All right, Mr. Elster, do you have someplace else you can live right now?
No, ma'am. No, ma'am. I can't go back to Hillview Road.
Do you have any family members in the area?
Only brother Bob.
I'm sorry?
Mother and brother here.
Your mother?
Brother here in Hillview.
Okay,
But I can't return to Hillview Road, ma'am.
okay,
Only brother Bob is in Idaho.
okay.
I have two brothers in
Do any of them live here in Hernando County?
mother and brother, that's it.
Okay, and can you go live with one of them for right now?
No, ma'am.
Why not?
Probably no. It's all against mother and it's all against brother.
Okay.
It's all a matter of public record.
Okay, because Salashans doesn't want you back there.
They do or don't, ma'am?
They do not. So, can you find someplace else to go?
Well, I called yesterday and I didn't hear back from them.
Yeah, I don't think they're going to be returning your phone call. What I was just told in the courtroom is that they're looking on evicting you and making sure that you don't go back there because they don't want you back there, sir. So do you have
The car is
something?
there.
I know you have some things there, and you're going to be permitted to go get your belongings.
My
So,
car is there and, excuse me, possessions in the apartment, ma'am.
yes, I understand. That's why I'm asking you, do you have someplace else you can move these things?
Yes, ma'am, when I find a new apartment. It's on Highway 41, I heard back from it, it's called
Oh, okay.
Candlewick Apartments in Brooksville.
Okay, perfect. Okay. So what I'm going to do is I'm going to set your bond at $100. We're going to see you back to court on January, I think it says 5th, January 5th at 9 a.m., okay? They're going to give you some paperwork there at the jail. And you need to get out and start working on this and get moving, okay?
Yes, ma'am.
All right. Thank you, sir.
Thank you, Your Honor.
Thank you.
Yes, Your Honor.
Okay, very good. Good afternoon, everyone. My name is Judge Healis. You're here today for first appearance. The purpose of this hearing is to inform you of the charges against you and determine whether there is probable cause for your arrest. Before court today, I reviewed all of the probable cause affidavits in your case. I have already determined whether there was probable cause for your arrest or not. If I found there was no probable cause, you will be released today. That does not mean that your case is dismissed. It just means the law enforcement officer did not give me what I needed in order to find probable cause, and you will need to come back to court another day. If I found probable cause, I will then ask you some questions to determine whether your bond will stay the same, increase, decrease, or whether there are any other bond conditions that would be imposed against you. Please only answer the questions that I'm asking here today. They're designed not to get you into any more trouble and designed not to violate your right to remain silent. You are entitled to have a lawyer represent you at each stage of these proceedings. If you cannot afford to hire one, I will appoint the public defender's office for you today. At this time, I'd like everyone to raise your right hand so I can place you under oath. Solemnly swear or affirm the testimony before the court will be the truth, whole truth, nothing but the truth. Can you all hear me? Why are your hands that up? I don't think they can hear me. Can I have everyone raise your right hand, please?
Somebody heard you.
One person.
I know they can hear me. They just choose not to. Raise your right hand in the back row, if you're here for me. Solemnly swear or affirm the testimony before the court will be the truth, whole truth, nothing but the truth. All right, go ahead and put your hands down. As I call your name, please come forward. John Petrie. Mr. Petrie, can I have your date of birth?
5/2/65.
You are here today for possession of controlled substance, possession of methamphetamine, possession of a new drug with no intent to sell, and possession of drug paraphernalia, and a domestic battery. There's probable cause for each of those. Do you want the public defender's office to represent you?
Yes, please.
I'll appoint the public defender's office. Does he have a criminal history?
Yes, Judge. He was adjudicated in 2019 for possession of cocaine, possession of a controlled substance, and possession of paraphernalia. Got 15 months DOC there. Got adjudicated 2017 for armed trespass, possession of cocaine, and possession of paraphernalia. Adjudicated again 2016 for trespass, resisting without possession of paraphernalia. Adjudicated 2014 for battery. Adjudicated 2014 for carrying a concealed weapon. Adjudicated 2014 for possession of paraphernalia and possession of a controlled substance. Adjudicated 2012 for burglary of a structure and grand theft. Adjudication 2011 for Willis. Adjudicated 2010 for DUI. Adjudication 2010 for Willis. Adjudication 2009 for possession of paraphernalia. Adjudication 2009 for witness tampering. Adjudication 2008 for possession of paraphernalia. Adjudications 2007 for possession of paraphernalia and criminal mischief. Keeps going. If you'd like me to keep going.
No, I'm good.
Okay.
All right, Mr. Petrie, I have an address for you on Morrison Way in Spring Hill. Is that where you live?
Yes.
How long have you lived there?
Way. For a couple months.
Okay, where'd you live before that?
Where I lived before that prison. What do you mean where I lived before? I just got out of prison.
Do you have a job?
No, I don't have a job.
I need to order that you have no contact with Jeannie Wingfield. Don't have any contact with her whatsoever. Do not call, do not write, do not email, do not have anyone else call her, write her, or email her. If you have any contact with Jeannie while this case is pending, you could be charged with another crime and held without bond. Do you understand that?
Yes.
I need to hold you until 4 o'clock today in case she needs to file any civil paperwork against you. I'm going to set your bond at $5,000 on each count. And I'll see you back to court December 30th at 1:30.
Can I ask you one question?
Sure.
I want to know why she got a warrant in another state and she ain't got no problem, no reason to come to jail or nothing. Just because she got a warrant in another state,
Okay.
that doesn't have nothing to do with nothing, right?
I don't know, sir. Thank you. Have a good day. Marcus Allen.
Oh, yeah.
Can I have your date of birth?
June 23rd, 95.
You're here today for a violation of probation. It's based on a warrant signed by Judge Hitzman on December 1st. So there's probable cause for your arrest. Do we have, I don't see a recommendation for probation.
10 days.
10 days? Okay. They're recommending 10 days in jail to resolve this. Would you like to take care of that today?
Yeah.
Okay. Do you understand that by admitting that you violated your probation, that you're giving up your right to have a hearing?
Yeah.
Giving up your right to confront witnesses at that hearing, call your own witnesses at that hearing, and you're giving up your right to have the state prove that you violated your probation. Do you want to give up those rights in order to take care of this case today?
Yeah.
Okay, with regard to the violation of probation on this possession of marijuana case in 2019 MM3644, do you admit that you violated?
Yeah.
I'll accept your admission. I find it's freely and voluntarily given. I'll adjudicate you guilty, revoke and terminate your probation, sentence you to 10 days in the Hernando County Jail. When you were initially charged with this crime, did you go to jail or did you just get a notice to appear?
It was a notice, Judge.
All right, very
I
good.
went to jail and got out.
I'm sure I'm noticed it.
I must be for something else. Okay, we're not reflecting that on here. So you have 10 days. You'll have $50, I believe, is the cost of prosecution in this case, and then you will be done. Okay.
Yeah.
All right. Thanks. Kevin Nobles. Can I have your date of birth?
9/2/81.
You are here today for domestic battery. I found probable cause for your arrest. Do you want the public defender's office to represent you?
No,
Are you going to hire somebody or are you going to represent yourself?
I represent myself.
Okay. Any criminal history?
All I'm saying is a withhold in 2018 for no motor vehicle registration.
I need to order that you have no contact with Sherry Sabatelli. Don't have any contact with her whatsoever. Do not call, do not write, do not email, do not have anyone else call her, write her, email her. You have to stay 500 feet away from her residence, employment, school, or vehicle. No text messaging or social media or technological contact whatsoever. I need to hold you until 4 o'clock today in case she needs to file any civil paperwork against you. And if you have any contact with her at all, you can be charged with another crime and held without bond. Do you understand that?
Yes.
I have an address for you on Sunridge Drive in Ridge Manor. Is that where you live?
Yes.
How long have you lived there?
2 years.
Okay, do you have a job?
No, I'm disabled.
Okay. I'm going to set your bond at $100. We'll see you back to court January 6th at 9 o'clock. Anthony DeBella. Can I have your date of birth?
10/02/57.
You are here today for a petty theft. There's probable cause for your arrest. Do you want the public defender's office to represent you, sir?
Yes.
All right, and do we have an offer today for it? That was a tag.
Did they recover the tag?
Yeah.
They did.
Yeah, it was on the car.
Yeah.
Okay. Well, he has no history, so I'd like to offer him PTI, but right now I'll just offer him a withhold pay and go.
Okay. If you want to resolve this case today, they will just have you pay court costs in the amount of $550. Is that something that you want to take care of the case today and make payment arrangements on it?
Yeah, I'll take care of it today.
Okay. Do you understand that by taking this plea today, you're giving up your right to go to trial?
Right? Yes, Your Honor.
Okay. Giving up your right to confront the witnesses against you, call witnesses on your own behalf, and you're giving up your right to have the state prove the case against you. Do you want to give up those rights in order to take care of this case today?
Yes, Your Honor.
With regard to this petty theft charge, how do you plead? You can plead no contest. If you plead no contest, it means that you can't contest the evidence against you and you're taking the plea in your own best interest. Would you like to plead no contest?
Yes, Your Honor.
I accept the plea of no contest to find this freely and voluntarily entered. Give you a withhold, fines and court costs of $550, and that includes the cost of prosecution. There's no restitution. All you need to do is you are releasable on this today. Once you have been released from jail, you can come down to the clerk of court and make payment arrangements for that $550, okay?
And Judge, I know he said he wanted us, but we
Yeah,
we
no
waived
problem.
pay.
Thank you.
You are, Your Honor.
All right, and we have Alejandro Batista.
Good afternoon, Your Honor. I was
Hi. Yes, it is. We have him there.
John, just give me 1 second.
Okay. Yes,
I'm not sure if you're aware he is going to need a Spanish translator.
we have one here waiting.
Yes, ma'am, thank you.
Thanks.
Capital N's. It doesn't matter. Okay. CPS info.net. No. I didn't make the first minutes. There's a recon. Oh, okay. Yeah, I saw it. So he pled yesterday in that term. He actually made it. Judge, if I might address something while we're waiting. Mr. Lascaris, I'll be sending you an email and copy in probation. He was a gentleman that back in August was sentenced to 20 days and had a turn-in date a day or two later and did not show up. And he's now in the Hillsborough jail. And the recommendation of probation, because it's about now, is 60 days. Originally it was 20. And the PD down there has been emailing me. So just so you're aware, it should be coming.
Thank you. Okay. If you could make sure that Mr. Batista can hear you.
Señor Batista, ¿me escucha?
Sí.
Okay.
Sí, gracias. ¿También Luis Mesó?
Yes. Yes.
Sí. Señor, seré su intérprete de inglés, todo lo que usted diga en español, lo voy a repetir tal como usted lo dijo en inglés, todo lo que diga la jueza en inglés, se lo voy a repetir tal y como ella lo dijo en español para que usted entienda. Por favor, hable en frases cortas y pausadamente para poder interpretar entre sí. ¿Está bien?
Ok.
Gracias.
Can you have him confirm his date of birth, please?
¿Me confirma su fecha de nacimiento, por favor?
25 de agosto del 88.
8/25/88.
Okay. Let him know that he is here for not having a valid driver's license.
¿Usted está presente por no tener licencia válida de conducir?
Sí.
That there is probable cause for his arrest.
Que si hay motivo fundado por su detención.
And I'm just going to ask the state attorney's office if there's a way that we can resolve the case today.
Y le voy a preguntar a la fiscalía si hay alguna forma de resolver el caso el día de hoy.
In adjudication, fines, court cost, and cost of prosecution. That's it.
Okay. The state has indicated that they're looking for an adjudication of guilt and fines and court costs of $450.
La fiscalía dice que quieren acepta de condena y multa y costas judiciales de $450.
If he wants to take that, he can make payment arrangements on the $450.
Si usted quisiera tomar esa oferta, puede hacer un arreglo de pagos para los $450.
Sí, quiero pagar la multa.
Yes, I would like to pay the fine.
Okay. So you understand that by taking care of it today, he's giving up the right to go to trial.
Usted entiende que con el resolver el caso el día de hoy que está renunciando el derecho de ir a juicio.
Okay.
Okay.
And he's giving up the right to confront the witnesses against him and call witnesses on his own behalf.
Está renunciando el derecho de enfrentar y contrainterrogar a los testigos en su contra y llamar a sus propios testigos.
Sí.
Does he want to give up those rights in order to take care of this case today?
¿Quisiera usted renunciar a sus derechos para poder resolver el caso el día de hoy?
Sí.
Yes.
Okay. How would he like to plead to this charge? He can plead no contest.
¿Cómo quisiera usted contestar a esta acusación? Puede contestar, no me lo pongo.
If he pleads no contest, that just means that he's taking a plea in his own best interest and he can't contest the evidence against him.
Si usted contesta no me opongo, solamente significa que está contestando a la acusación y no me opongo en su mejor, porque es en su mejor interés y que no puede refutar a las pruebas en su contra.
No me opongo.
No cambio.
I'll accept his plea of no contest, defendant's freely and voluntarily entered, adjudicate him guilty, sentence him to fines and court costs of $450.
Acepto su contestación de no me opongo a la acusación, lo hallo libremente voluntariamente integrada y haciendo condena, le impongo multa y costas judiciales de $450.
He can make payment arrangements at the courthouse in room 136.
Puede hacer un arreglo de pagos aquí en el Palacio de Justicia, en la sala 136.
That's it. Thank you.
Gracias.
Thank you, Ryan.
Thank you, Your Honor. Have a great
All right,
day.
thanks, you too.
Require further interpretation?
No, sir, we could continue.
Differences between 0.7 to the score sheet.
That's fine. This here is all. This was he's going to put it on.
These are the only cases. It's 20 TF 2535 80 3297. I thought this was a lead of the global, but
Well, that's what I was hoping. See, it's going to be
they're
364.
they're all driving cases. So. The VOP and the D lane.
Right. I think assuming that one's going to be the heaviest sentence. My idea is globally see out all the other. Or just,
I mean,
like some sort of jail sentence would probably be best.
I mean, I don't know if the judge is going to accept this offer because realistically, he's more than 364. That's the one I intended to present to the judge when he asked for it. But he, without the new law, I mean, the difference is going to be 0.7.
Without
the new law, the additional score.
That's what I put Mr. I mean, technically, it hasn't pled out to me.
Right. I don't know if you're planning to plead it here or you're planning to plead it. Then that's fine.
The only thing is, I thought there was
What's up?
You're fine that they got us updated records. We had an issue with the tattoo issue. The judge.
Yeah, I saw the order. It came out in second. What are you looking for out of this? He's got anxiety. Figuring out. That makes sense. Okay. So what are we looking for out of this hearing? Because I mean, it's a neuro. The reassessment that goes into it.
It's a combination.
That's what I'm saying. Like, no matter how. Except this one.
No, I'll be your example.
What you always hear me tell Ari. What's up, pretty girl?
All right, good morning, folks. If you will please, if you're on with us via Teams, if you'll please mute your microphone. Folks, sorry. Thank you. Okay, we've got a lot of matters on the docket this morning. We have the jail feed initially, so we'll start with the folks who are in custody.
all the context.
Okay, Mitch Lapuka. Mitch Laputka.
Two is Lapuka's quarantine. So we're going to do it again on the quarantine inmates.
All right, do we have Regional Conflict Council? I don't see.
His next door.
Okay. All right, thank you. Okay, unfortunately, that was the only one that was marked as in custody, so. I don't know who we have. Have any counsel that have a client who's in custody they want to address this? Right.
Melissa Vickers, I'm here on Chris Nunez.
Okay, yes. Find that. I'm sorry?
Nunez, they scratched it out from the docket because it says that he pled on Judge Wooden court on November 16th.
No, sir, we were here 2 weeks ago. This is a Judge.
Okay, what's the case number, please?
It's 2009 CF 3961, and then 2009 CF 724, and then there's a cross-county plea from Columbia County. We were here 2 weeks ago, and there was an issue about credit time served in the Department of Corrections, and Your Honor reset this for this morning for a plea. I've got it all worked out, and we're ready to go.
No, we don't have Mr. Nunez because he wasn't on the list. For some reason, the clerk took it off. So we'll have to see if we can get Mr. Can we get Christopher Nunez brought?
Yes, sir, he's right here.
Oh, he is here. Okay, excellent.
If you need time, we can recall this.
That's all right. So it's 09CF3961. The other 09 case was?
09 CF 724.
And then the out-of-county case.
You want the Columbia County case?
No, I don't need the case number. I need the plea forms if you
Oh,
have.
yes, sir.
Okay. Oh, I need it.
You may. Thank you. All right.
Oh, I think I gave you the wrong form. I'm sorry for Columbia. So it just has the updated date.
Okay. All right, Mr. Nunez, good morning, sir. If you raise your right hand. Do you solemnly swear or affirm the testimony you are about to give will be the truth, the whole truth, and nothing but the truth? State your name, please. All right, Mr. Nunez, you were here this morning in 3 cases. We should have, Madam Clerk, in the Columbia County, I should have a packet with the So we don't have a copy of the affidavit of violation of probation? Does the state or defense have that?
Yes, sir.
Okay. Yes, thank you. Okay, 222, correct. Mr. Nunez, in Columbia County case 19 CF 222, you were placed on probation for possession of contraband in a state correctional facility, which is a third-degree felony punishable by up to 5 years state prison, 5 years probation, and/or a fine of up to $5,000. Do you understand?
Your Honor, actually, it's a secondary felony.
Oh, I'm sorry, you're right. Second-degree felony, punishable by up to 15 years state prison, 15 years probation, and/or a fine of up to $10,000. Do you understand?
Yes, sir.
You've been accused of violating your probation in that case. It's alleged that you violated Condition 5 by committing the offense of battery by strangulation or lesser included offense in Osceola County on July 11th of 2020. Do you understand?
Yes, sir.
If you admit that you willfully violated your probation can be revoked and terminated. You could be sentenced to up to 15 years state prison. Do you understand? And do you wish to admit that you violated your probation as alleged? Okay. In Osceola County case 9 CF 3961, you were placed on probation for burglary of a dwelling, which also is a second-degree felony, punishable by up to 15 years state prison, up to 15 years probation, and/or a fine of up to $10,000. Do you understand? You've been accused of violating probation in that case. Again, it's alleged that you did so by committing domestic battery by strangulation on about July 11th of 2020 in Osceola County. Do you understand? Okay. And again, if you admit that you willfully violated your probation can be revoked. You could be sentenced to up to 15 years state prison. Do you understand?
Yes, sir.
Okay. In case 9 CF 724, we have the burglary dwelling listed. The other probationary periods expired or for the violation?
No, sir.
Because he was placed on probation on 5 counts.
No, sir. What happened was he was placed on probation for a secondary felony and then several third-degree felonies. We
Right.
did a motion to correct the sentence because he was given prison time. And then
Right, he got the 5 years DOC on,
Right.
okay.
So Judge Wooten corrected that maybe within the last month to correct the sentence to 5 years DOC on the third-degree felonies. So
Okay, I
technically
got
we're on
you.
probation for the
Okay.
second-degree felonies.
All right, here's the amended order, yeah. So the probation was just to count one. So, Mr. Nunez, in case 9 CF 724, you were placed on probation for burglary of a dwelling. Again, punishable by up to 15 years state prison, 15 years probation, and/or a fine of up to $10,000. The allegation is that you violated the probation in the same manner as in the other two cases. Do you understand?
Yes, sir.
And do you wish to admit that you violated probation in that case as well?
Yes, sir.
All right, did you read and understand the written admission forms?
Yes, sir.
Do you have any questions about anything on the written admission forms? Are you currently under the influence of any medication or other drugs or alcohol?
No, sir.
Are you thinking clearly at this time? Has any person coerced or forced you in any way to enter these admissions? Okay. The recommendation in each of these cases that the court would revoke and terminate your probation. That as to cases 09 CF 3961 and 09 CF 724, you'd be sentenced to 2 years in the Department of Corrections with credit for 153 days that you've served since your arrest on the violation of probation. All prior credit would be waived, and the sentence would run concurrent with the as to each case, and the sentences will run concurrent with the Columbia County case. Any outstanding financial obligations will be ordered to be paid through the clerk's collection program. Is that your understanding? In case 19 CF 222, the Columbia County case, the recommendation is that the court would revoke and terminate your probation. You'd be sentenced to 36 months in the Florida Department of Corrections with credit for 364 days time served. Again, all other credit you may have in the sentence would be waived as a condition of the plea. And you'd be required to pay $100 cost of prosecution. Any other outstanding obligations will be reduced to a civil lien in that case. Is that your understanding of the agreement?
Yes, sir.
All right, you've been represented by Ms. Vickers in these cases. Are you fully satisfied with your lawyer? Do you believe it is in your best interest to enter these admissions? Do you understand that you have the right to have a hearing in these cases to determine whether the state can prove that you did willfully violate your probation?
Yes, sir.
If you chose to go to hearing, at the hearing you could not be found guilty of any violation unless the state proved by the greater weight of the evidence that you did violate your probation as alleged. You would have the right to be represented by Ms. Vickers throughout the violation of probation hearings. You would have the right to confront and cross-examine witnesses who testified against you. You'd have the right to present witnesses and evidence in your defense. You are entitled to have the court order any witnesses you have to be present at your hearings. You also would have the right to testify yourself. Since the only alleged violation is the commission of a new offense, you could also choose not to testify. And if you chose not to testify, the fact that you elected not to testify would not be considered as evidence of guilt. You understand that you have those rights. By entering these admissions, you're giving up the rights we've discussed, as well as the other rights that are written on the admission forms. And there won't be any further hearing in either of your case or any of your cases other than a sentencing hearing. Do you understand? You also are waiving your right to appeal any matters relating to these cases other than this court's jurisdiction to hear the cases and the legality of any sentence the court might impose. Do you understand?
Yes, sir.
And specifically with respect to the Columbia County case, you are waiving your right to appeal this court's jurisdiction under the Supreme Court order, which grants the court jurisdiction to hear the case for an admission, and you're waiving your right to appeal any objection to venue of the case being in Osceola County. Do you understand? All right. All right, I find that you are alert and intelligent, that you understand the nature of the allegations against you and the penalties you're facing. You understand the rights that you're giving up by entering these admissions. I find that your decision to enter the admissions has been freely and voluntarily made, and that you've had the advice of competent counsel with whom you've expressed satisfaction. I'll accept the admissions of violation of probation. State, do we have a score sheet? I've got a score sheet from Columbia County, but it's not accurate. It only lists the Columbia County. I guess this. Right. All right. All right, I have a score sheet with 99.4 total sentence points. Any objection to that? Ms. Vickers?
Yes, Your Honor, they have the contraband both listed under additional offenses and under prior record. They don't score any points.
Okay, well, I can mark through it, that's fine.
But just for the record, that it shouldn't be on there. But no, I don't have an objection to actual number of points.
Okay, anything further to be said with respect to sentence?
No, Your Honor.
All right. Mr. Nunez, in case 9 CF 724, I will revoke and terminate your probation. You'll be sentenced to 2 years in the Florida Department of Corrections with credit for 153 days time served, and by stipulation, all prior credit for time served is waived. You're ordered to pay the outstanding financial obligations of $530.37 through the Clerk's Collection Program at the rate of no less than $50 every month. You'll have until March 1st of 2023 to make your first payment. In case 9 CF 3961, I will revoke and terminate your probation. You'll be sentenced to 2 years in the Florida Department of Corrections with credit for 153 days time served. All additional prior time served, credit for time served is waived. You're ordered to pay the outstanding financial obligations of $502.92 at the rate of no less than $50 per month through the Clerk's Collection Program consecutive to the payments ordered in case 09 CF 724. The sentence in case 09 CF 3961 will run concurrent with the sentence in case 09 CF 724. In Columbia County case 19 CF 222, I will revoke and terminate your probation. You'll be sentenced to 36 months in the Florida Department of Corrections with credit for 354 days time served. Any additional credit for time served is waived. You're ordered to pay out any outstanding financial obligations in this case, plus a $100 cost of prosecution as a civil judgment. The court will reduce to a civil judgment. The sentence in Columbia County case 19 CF 222 will run concurrent with the sentences in Osceola County cases 9 CF 724 and 9 CF 3961. Is there anything further with respect to the sentences?
No, Your Honor. Thank you.
All right, Mr. Nunez, you have 30 days within which you can appeal the judgments and sentences that were just entered in your cases. If you wish to appeal and you cannot afford to hire a lawyer to assist you, I will appoint one. If you do not file a notice of appeal in writing within 30 days of today's date, you waive your right to appeal. Do you understand, sir? All right, thank you, sir. Good luck to you. Excuse me. Thank you, Ms. Burkett. Mr. Freitas?
Yes, good morning, Your Honor. Brian Freitas. I have Mark Rodriguez. He is at the jail, Your Honor.
Right.
We were set for a plea status this morning.
Yes, sir.
I was under the impression that they would be transported over here, so I have the plea forms, everything ready. He just hasn't signed them. I don't know if I can run over there real quick.
I doubt that's going to be able to be accomplished. I can reset it for next Friday if you want.
Next Friday should work.
What name is the?
Rodriguez?
Mark Rodriguez.
Yeah, next Friday works.
Okay, we're going to reset Mr. Rodriguez's cases for Friday, the 18th at 8:30. Mr. Rodriguez, your attorney needs to get you to review plea forms, and if you wish to enter a plea, that's fine. We're resetting it for next Friday. Thank you, sir.
8:30.
Brian, just shoot me an email with the Orange County case.
Yeah.
So I can just add it.
All right, do we have any other counsel with a client who's in custody? Mr. Blanco?
Good morning, Mark.
Morning.
John Carlos Torres.
Okay.
Morning, Dave.
All right, and this is a status hearing in case 18 CF 911. What's happening in this case, Mr. Blanco?
Judge, I was trying to get out to speak to Mr. Torres. I did not have a chance to go out there and talk to him about what was going on with the case. I know he tried to contact me, possibly through the jail. This is my fault. I'm going to carve out some time. I want to resolve this case before Your Honor leaves, at the end of the month. So I was hoping. I asked the state if they had any problem with me just resetting this till Friday, till next Friday, so I can get everything squared away. And they didn't have an issue with that. I was hoping that Mr. Honor would give me some time. This week was hectic for me. I just didn't have a chance to get out there to speak with the Torres.
Okay, so okay. State any. All right, Mr. Torres, we're resetting your case to next Friday, December 18th at 8:30. Thank you.
Thank you. Mr. Torres, I'll be out there to talk to you, okay?
Do we have any counsel? Do we have any counsel on teams who have a client who's in custody?
Your Honor, I do. Mr. Suarez, room clients in custody, Pierre Louis, with the Creole interpreter.
I don't see you here, Mr. Suarez.
Showing on mine, he's in the waiting room twice, so I don't know if he's having technical difficulties.
Okay, I see that. All right, Mr. Suarez, can you hear us? You appear to be muted, maybe. Morning, Mr. Suarez. Mr. Ms. Suarez, that doesn't seem to be working too well. I'll try admitting him again. and see what. Ms. Suarez, it appears that you're here and you're here twice, so let me.
Maybe that's close.
If you drop off one of those, that should help. Okay. Can you hear us? Not a good morning for technical difficulties. All right, Ms. Suarez, are you with us? All right, any other counsel that have a client who's in custody? We've got a lot of folks sitting there. All right, maybe those are arraignments.
Are you doing private or are you doing anybody?
I'm doing anybody. We need to take care of we need to take care of these folks who are in jail so we can get to the other feed.
Sounds good. I have a.
Just a minute, Ms. Suarez. We moved on, so we'll come back to you.
I have Mr. Pantojas Mina. He'll be a change of plea this morning.
Okay. Okay, I got you. Okay. Mr. Pantojas, if you'll raise your right hand, sir. Do you solemnly swear or affirm the testimony you are about to give will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
State your name, please.
Albert Pantojas.
Mr. Pantojas, I've been given a plea form by Mr. Mendoza, which says you wish to enter a plea of no contest to the lesser included offense of burglary of a structure in case 20 CF 1925. Is that what you want to do? And state you agree to the plea to the lesser offense?
Yes, Judge, this is an uncoerced plea bargain with an agreement to a lesser included burglary of a structure.
All right. Charge of burglary of a structure is a third-degree felony punishable by up to 5 years state prison, 5 years probation, and or a fine of up to $5,000. Do you understand?
Yes, sir.
Did you read and understand the written plea form? Do you have any questions about anything on the written plea form?
No, sir.
Are you currently under the influence of medication, other drugs, or alcohol?
No, sir.
Are you thinking clearly?
Yes, sir.
Has any person coerced or forced you to enter this plea?
No, sir.
The recommendation is that you will be adjudicated guilty, sentenced to 5 months in the county jail with credit for 125 days that you've already served. You'd be required to pay, followed by 18 months of drug offender probation. You'd be required to pay fine, court costs, public defender lien, and application fee. There'd be a requirement you complete 100 hours of community service. You not have contact with the named victim or return to the area of the offense. Is that your understanding of the agreement?
Just in my understanding, I thought the community hours were going down to 75 hours.
No.
Judge, if I may, I was talking to Mr. Pantojas about that. Mr. Pantojas, I spoke to the state, and he does not agree to that. It'll stay at 100.
All right, no problem.
Okay.
Thank you.
All right, Mr. Pantojas, are you satisfied with the services of your lawyer?
Yes, Your Honor.
Do you believe it is in your best interest to enter the plea?
Yes, sir.
Do you understand that if you are not a United States citizen, entering the plea will subject you to deportation?
Yes, sir.
If you at any time are sentenced to state prison, and if you have ever previously been convicted of a sexually motivated or sexually violent crime, once you complete any sentence the court might impose, you could be committed civilly for an indeterminate period of time as a sexually violent predator. Do you understand?
Yes, sir.
You have the right to have a jury trial. If you chose to go to trial, at trial you would be presumed to be innocent. You could not be found guilty unless a jury unanimously found the state had proven your guilt beyond reasonable doubt. You would have the right to be represented throughout your trial by Mr. Mendoza. You would have the right to confront and cross-examine witnesses who testified against you. You would have the right to present witnesses and evidence in your defense. You have the right to have the court order any witnesses you have to be present at your trial. You also have the right at trial to testify yourself, or you could choose not to testify, and if you chose not to testify, you have the right to have the jury instructed they could not consider the fact that you chose not to testify as evidence of guilt. And do you understand that you have those rights?
Yes, sir.
By entering a plea of no contest, you're giving up each of the rights we've discussed, as well as the other rights written on the plea form, and there will not be a trial in your case. You also, by entering a plea, are waiving your right to appeal any matters relating to this case, with the exception of the legality of the sentence imposed and the court's jurisdiction to hear the case. Do you understand?
Yes, sir.
All right. I've read the arrest affidavit of Deputy Wilson, and I find based on that affidavit, there's a factual basis upon which your plea can be accepted. I find that you are alert and intelligent, that you understand the nature of the charge against you, the penalties you're facing, and the rights you're giving up by entering the plea. I find that your decision to end the plea has been freely and voluntarily made, and that you've had the advice of competent counsel with whom you've expressed satisfaction. I will accept the plea of no contest. Mr. Mendoza, is there any objection to the score sheet with 32.5 total sentence points?
No, Your Honor, no objection.
Is there anything further with respect to sentence?
None at this time, Your Honor, thank you.
All right, Mr. Pantojas, you will be adjudged guilty of the lesser included offense of burglary of a structure. You'll be sentenced to 5 months in the Osceola County Jail with credit for 125 days time served, which will be followed by 18 months of drug offender probation. You are required to pay court costs of $415, a $100 cost prosecution, a fine of $500, $100 public defender lien, and $50 public defender application fee. Monies are to be paid at the rate of no less than $50 every month, beginning no later than the third month of your probation. You're required to complete 100 hours of community service at the rate of no fewer than 8 hours every month, beginning no later than the second month of your probation. You are not to return to the area of 852 Desert Mountain Court in Kissimmee. You're not to have any contact directly or indirectly with Kristen Denise Tubbs. You'll be required to submit a biological specimen for inclusion in the Florida Department of Law Enforcement DNA database. You are required to report to the probation office no later than 2:00 p.m. on the next business day following the release from custody. You have 30 days to appeal. The judgment and sentence was just entered. If you wish to appeal and you cannot afford to hire a lawyer, I will appoint one to represent you. If you do not file an appeal in writing within 30 days of today's date, you waive your right to appeal. Do you understand?
Yes, sir.
All right, thank you, sir.
Thank you, Judge. One last thing is that he has to go back to Seminole County to handle matters there.
Okay.
But I think your order was clear enough about reporting application. Thank you, Judge.
Excuse me.
I do have another matter that's ready, or I can wait.
Yeah, go ahead.
Okay. I have a motion for pretrial release on Mr. Gandy, Alfred Gandy.
Okay, this is case 20 CF 3422. And, you may proceed.
Thank you, Judge. If I could call Mr. Alfred Gandy.
Mr. Gandy, raise your right hand. Do you solemnly swear or affirm the testimony you're about to give be the truth, whole truth, nothing but the truth?
Yes, sir.
State your name, sir.
Alfred Gandy.
All right, you may proceed.
Thank you, Your Honor. Mr. Gandy, can you hear me okay?
Yes, sir.
Thank you. If you were released today, where would you be residing?
I'll be residing at 1701 Madison, apartment 1-104.
And who lives at that address other than you?
Julie McGee.
And who is that in relationship to you?
Got my son on, and that would be my fiance.
All right. right. And how long have you lived in this area?
I've been staying there since 2014.
And were you working prior to incarceration?
Yes, sir.
And where were you working?
I was working for the labor board.
All right, so were you working full-time, part-time, or just as many hours as you can get?
Full-time.
And how much were you making on a week?
What I was making a week was probably
Okay, and can you afford a bond right now?
No, sir.
Can you please tell the court why you can't afford a bond even though you have a job?
Because I got to take care of my son. You got my son sick.
All right, and isn't there something else you just shared with me that happened to you recently?
Yes, my sister had passed away.
And when did she pass away?
She passed Thanksgiving.
And do you know why she passed away?
She had now passed away by sickle cell.
All right, and is there a funeral scheduled?
Sad.
And who is assisting in paying for this funeral?
Me and my brother, we were on insurance.
Okay, and other than your brother, do you have any other family here in town?
No.
Okay. All right. Do you have a passport?
No, sir.
Do you have a bank account?
No, sir.
Do you have any cash in your property at this time?
No, sir.
Do you own any property?
No, sir.
All right, nothing further, Your Honor.
All right, State, any questions?
Yes, Judge. Can you hear me okay, Mr. Gandy?
Yes, sir.
Okay, you stated just moments ago you don't have any kind of bank account whatsoever, right?
I got no bank account, sir.
Do you have a full-time job though?
Yes, sir.
Okay, where are you putting your money?
Well, I was putting my money, I was putting for my addiction.
Okay. Do you have any family outside of the state of Florida?
Outside of Florida, yes, sir.
Where?
Boston.
How many family members?
I've been like a lot.
10, 20, 30,
20.
20?
Yes, sir.
Okay. Do you visit there often?
No, sir.
When's the last time you've been to Boston?
It's been years.
I'm sorry, I couldn't hear that.
It's been years.
2 years, 3 years, 4 years,
It's been about like 15.
15 years. Do you have any other family members or close relatives, friends that live outside of the state of Florida?
No, sir.
I have nothing further, Judge.
All right, thank you. Any additional evidence or testimony, Mr. Mendoza?
No, Your Honor, brief argument.
State, any evidence or testimony?
Just a score sheet to present, Judge. I've sent this before. It's most of this is. May I approach?
Right. Argument, Mr. Mendoza?
Yes, Your Honor. Mr. Gandy can't afford a bond at this time. He lost his family member during Thanksgiving. He has substantial ties to the community. He's not a flight risk. He hasn't been to Boston in about 15 years. Looks like most of his record is here out of Osceola County. We're asking the court to please release him, pretrial release, so that he can attend his sister's funeral beginning tomorrow. And I believe that will be sufficient contacts with the court with regards to him being placed on pretrial release. And I know because this is a drug type offense, I know Mr. Gandy could abide by drug offender conditions. That's all, Your Honor.
All right, State.
Judge, taking a look at the score sheet, this offender has about 59.2 total sentencing points. He has some BOPs, respectfully, they are from the 1990s. His most recent offense was a drug issue that was added in 2020 of this year. So as far as whether he should be released or not, Judge, I've spoken with defense about this. I had no objections to a lower bond. The problem with this type of case is it doesn't suggest that it should be a straight PTR. Having an $11,000 bond is sensible considering the nature of the charge, sale and delivery within 1,000 feet of a school or place of worship in this case. It should be maintained where it is. Understanding that the loss of someone is tragic, I get that, but it's not reason for a reduction in his bond. The proper tool and avenue would be a furlough if that was being sought for this particular purpose. So the state would be asking for a denial of the motion for a straight PTR. Bond and a financial incentive is likely the only reason why the defendant can stick around.
All right. Okay, Mr. Gandy's been here for a while. He's sent to DOC in 2017, got out in 2018, I believe. Hasn't had a whole lot of trouble since then. I'm going to deny the motion for pretrial release. I'll reduce the bond as count one to $2,500, count two $150. It will be conditioned upon supervision by pretrial release with no alcohol, no drugs, drug testing. All right. Thank you, folks.
Thank you, Judge.
If you post bond, and yes, sir. Thank you. Well, I'm sorry. You can talk to the jail about whether they can make arrangements for you to attend the funeral, but your bond is what it is. Thank you, sir. All right. Other in custody folks, PD or Ms. Smith, did you have?
Yes, Judge. I have Tyrone Hartman. He shouldn't be in a court.
I'm sorry, what's the last name?
Hartman.
I'm not finding him.
He is on page.
Well, I don't have pages, so that doesn't help.
He's in the beginning of the docket. He's on the 815 section.
Oh, here he is. Okay, yes, thank you. All right, Mr. Hartman, good morning, sir. State your name. All right, Mr. Hartman, you are here for arraignment in case 20 CF 1387. And as soon as this comes through, okay, there we are. You are charged in this case with grand theft in count one and grand theft in count two. Each of those two counts is a third-degree felony, punishable by up to 5 years state prison, up to 5 years probation, and/or a fine of up to $5,000. Do you understand what the charges are?
Yes, sir.
How does he wish to plead?
We'll enter a not guilty plea, Judge. The state did make an offer yesterday afternoon, which I believe Mr. Hartman would accept, with 6 months jail. So I'm in the process. I didn't have a chance to get out there and get it signed, so.
Fair enough. I'll accept the plea of not guilty. We'll set the case for the February 1st trial docket, pretrial January 20th. Mr. Hartman, your lawyer will be talking to you earlier about your options, and if you decide to resolve the case otherwise, we can have you brought over early. That's fine. Your lawyer will talk to you about that.
So as soon as I get the
Thank you.
Judge, I'll move it up.
Thank you, sir. Okay. Okay.
Alphabetically, the first one would be Holden.
All right. Joseph Holden.
The second one alphabetically, I guess.
Mr. Holden, raise your right hand, sir. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, nothing but the truth?
Yes, sir.
State your name, please. All right, Mr. Holden, in case 19 CF 2976, Mr. King submitted a written plea form which says you wish to admit that you violated your probation in this case. Is that what you want to do? Okay, you were placed on probation in this case for possession of heroin is charged in count one, possession of controlled substance is charged in count two, possession of drug paraphernalia is charged in count three, and possession of, and Resisting merchandise recovery is charged in count 4, as well as petty theft as charged in count. The petty theft was not probation, okay? That's all right. Do you understand, sir? The maximum penalty for possession of heroin and possession of controlled substance is 5 years state prison, 5 years probation, and/or a fine of up to $5,000. For the other 2 counts, it's up to 1 year in the county jail, 1 year probation, and/or a fine of up to $1,000. Do you understand? Okay, you've been accused of violating as follows. It's alleged that you violated condition 3 by leaving Seminole County, which was your county of residence, and entering Osceola County on September 4th of 2020 without prior approval of your probation officer. It's alleged you violate condition 5 by committing offenses of trafficking in methamphetamines, trafficking in heroin, manufacture or delivery of drug paraphernalia, possession of heroin with intent to sell or deliver, possession of amphetamines, all on or about September 4th of 2020 in Osceola County. It's alleged that your possession of amphetamines and possession of heroin also violate condition 7 of your probation order. It's further alleged that you failed to pay the fines and court costs as ordered. Do you understand what the allegations are? If you admit that you willfully violated your probation, again, your probation can be revoked and terminated. You could be sentenced to anything up to the maximum legal sentence, which would be up to 12 years in incarceration. Do you understand? All right. Did you read and understand the written admission form? Do you have any questions about anything on the written admission form? Are you currently under the influence of medication, drugs, or alcohol? Are you thinking clearly? Has anyone coerced or forced you to enter this admission? The recommendation is that the court revoke and terminate your probation, that you be sentenced to 12 months in the Osceola County Jail with credit for the time you've served. You're required to pay the outstanding financial obligations, plus a $100 public defender lien through the clerk's collection program. Is that your understanding? And state you're recommending the downward departure sentence?
That's correct, Your Honor.
Okay. All right. Mr. Olden, you have the right to have a hearing in this case to determine whether the state can prove that you did willfully violate your probation. If you chose to proceed to hearing, you could not be found guilty of any violation unless the state proved by the greater weight of the evidence that you did violate your probation as alleged. You would have the right to be represented throughout the hearing by Mr. King. You would have the right to confront and cross-examine witnesses who testified against you. You would have the right to present witnesses and evidence in your defense. You have the right to use of the court's subpoena power to require any witnesses you had to be present at the hearing. You also have the right to testify yourself at the hearing. You could choose to remain silent with respect to the allegation you committed new criminal offenses while on probation. You could be required to testify with respect to other alleged violations. Do you understand? By entering the admission, you're giving up the rights we've talked about, as well as the other rights that are written on the admission form, and there won't be any further hearing other than a sentencing hearing. You also, by entering the admission, are waiving your right to appeal any matters relating to the case other than this court's jurisdiction to hear the case and the legality of the sentence imposed. Do you understand?
Yes, sir.
I don't know if I asked or not, but are you satisfied with your lawyer?
Yes, sir.
All right, I find that you're alert and intelligent. You understand the nature of the allegations against you, the penalties you're facing, and the rights you're giving up by entering the admission. I find that your decision to enter the admission has been freely and voluntarily made, and you've had the advice of competent counsel with whom you've said you're satisfied. I'll accept the admission in violation of probation. Mr. King, any objection to the score sheet 58.4?
No, Your Honor, no objection.
Anything further with respect to sentence?
Nothing from the defense. Thank you.
All right. Based on the uncoerced plea agreement between yourself and the state, the court will impose a downward departure sentence. I will revoke and terminate your probation. What's the time served, Madam Clerk? You'll be sentenced to 365 5 days in the Osceola County Jail with cut for 200 days time served as to each count running concurrent in order to pay the outstanding financial obligations, which total $1,258, plus a $100 public defender lien for representation in this proceeding. The monies ordered to be paid through the clerk's collection program at the rate of no less than $50 every month. Your first payment will be due no later than August 1st of 2021. You have 30 days to appeal the judgment and sentence which just entered. If you wish to appeal and you cannot afford to hire a lawyer, I will appoint one to represent you. If you do not file an appeal in writing within 30 days, you waive your right to appeal. Do you understand? Thank you, sir. All right, your next case, Mr. King.
The next one would be Reginald Johnson.
All right, Reginald Johnson, come on up, please. Raise your right hand, sir. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, nothing but the truth? State your name, please. Excuse me. All right, Mr. Johnson, you were placed on probation, case 15 CF 3676 for attempted lewd or lascivious molestation, which is a second-degree felony punishable by up to 15 years state prison, 15 years probation, and/or a fine of up to $10,000. Do you understand? You've been accused of violating the probation. It's alleged you violated Condition 8 by failing to diligently work at a lawful occupation or diligently work towards obtaining a lawful occupation. It's alleged you violated Condition 9 by untruthfully answering inquiry by your probation officer as to your whereabouts on March 29th of 2020. It's alleged that you violated Condition 9 by failing to comply with the instruction of your probation officer to contact Dr. Sandra Davis to begin sex offender treatment. It's alleged you violated Condition 15 by violating your curfew, by being away from your residence on March 29th of 2020 during curfew hours. It's alleged you violated Condition 17 by failing to enter and successfully complete a sex offender treatment program. Do you understand what the allegations are? If you admit that you willfully violated your probation can be revoked and terminated. You could be sentenced to up to 15 years state prison. Do you understand? Do you wish to admit that you violated your probation as alleged? I'm sorry? Do you wish to admit that you violated your probation as charged, sir? Okay. We'll set the case for a violation of probation hearing on January 28th. Status hearing is January 26th.
You wish to move forward with,
I'm sorry, we've done this twice. I'm not going to do it again.
You wish to admit the violation and go forward with the plea? Yes, sir. Did you just get confused with the negatives? Yeah. Do you want to admit?
Mr. King, don't dig in a hole any deeper.
All right.
It's all right.
And Your Honor.
Excuse me, if I could talk to Mr. Johnson for a moment. Mr. Johnson, the question was very simple. You've been accused of violating your probation.
Yes.
Do you want to admit that you did willfully violate your probation, or do you want to have a hearing to determine whether or not the state can prove that you did willfully violate your probation? So are you telling me that you do want to admit that you did willfully violate your probation? I'm not asking you that question. Do you want to admit that you willfully violated your probation or not?
Yes.
Okay, it's a simple question. Calls for a simple answer.
Mr. Johnson.
Excuse me, Mr. King, please don't interrupt. I'm sorry, Mr. Johnson. What else are you saying, sir? Well, everyone wants to go home. Okay. Well, we'll get to that. All right. Mr. Johnson, did you read and understand the written admission form?
Yes, sir.
Do you have any questions about anything on the written admission form?
No, sir.
Are you currently under the influence of medication, drugs, or alcohol?
Yes, sir.
Are you thinking clearly, sir?
Yes, sir.
Has any person coerced or in any way forced you to enter this admission?
No, sir.
And counsel, if you'll announce the terms, it's hard for me to read what.
Yes, Your Honor, it's to admit the violation and to reinstate on all additional terms with any back costs, court costs, and the public defender lien.
Is that your understanding of the agreement, sir?
Yes, sir.
All right. Are you satisfied with your lawyer?
Yes, sir.
Do you believe it is in your best interest to enter this admission?
Yes, sir.
You do have the right to have a hearing in this case. If you chose to go to hearing, you could not be found guilty of any violation unless the state proved by the greater weight of the evidence that you did violate your probation as charged. Do you understand? You would have the right to be represented by your lawyer throughout the hearing, and you would have the right to confront and cross-examine any witnesses who testified against you. Do you understand?
Yes, sir.
You would have the right to present witnesses and evidence in your defense at the hearing if you chose to go to hearing. Excuse me. And you would have the right to have the court order any witnesses you have to be present at the hearing. Do you understand?
Yes, sir.
You also would have the right to testify yourself at the hearing. Do you understand?
Yes, sir.
By entering an admission, you're giving up the rights we've talked about, as well as the other rights that are written on the admission form. And there will not be any further hearing in your case other than a sentencing hearing. Do you understand? You also, by entering the admission, are waiving your right to appeal any matters relating to your case other than this court's jurisdiction to hear the case and the legality of the sentence imposed. Do you understand, sir?
Yes, sir.
All right. You have a score sheet, see? Mr. Johnson, I find that you're alert and intelligent, that you understand the nature of the allegations against you, the penalties you're facing, and the rights you're giving up by entering the admission. I find that your decision to enter the admission has been freely and voluntarily made, and that you've had the advice of competent counsel with whom you've expressed satisfaction. I'll accept the admission of violation of probation. Any objection to the score sheet with 126 total sentence points, Mr. King?
No, Your Honor.
Anything further with respect to sentence?
Nothing from the defense, thank you.
Okay. And what's the time served?
2:39.
All right, Mr. Johnson, I will follow the recommendation. I'm going to reinstate you to probation in this case. Your probation will be modified to require that you serve 239 days in the county jail with credit for 239 days that you have already served. It'll be further modified to require that you pay an additional $100 public defender lien for representation in this proceeding. You'll be released from the county jail as to this case today. You need to report to the probation office no later than 9:30 tomorrow morning. I'm sorry, it won't be tomorrow, it'll be Monday morning. No later than 9:30 Monday morning, December 14th. You can go ahead and report today if you get out in time to do so, but no later than next Monday morning. Okay? Excuse me. You got 30 days to appeal the judgment and sentence was just entered. If you wish to appeal and you cannot afford to hire a lawyer, I will appoint one to represent you. If you do not file an appeal in writing within 30 days, you waive your right to appeal. Do you understand? All right, thank you, sir. Okay, Mr. King?
The next defendant, Your Honor, is Jose Lorenzo Montanez. He has two cases, a violation of probation and a new law. Your Honor, Mr. Lorenzo Montanez tells me that we had a plea conference and that you offered him 120 days which was different from the 180 that the state offered him. And I just didn't put that in my note system, so if I don't have it in that system, I don't remember it. So I just wanted to bring that to the court's attention before we move forward.
Okay, does the state concur?
Judge,
I don't see that note.
I have that anywhere in my notes.
Yeah, I don't remember that.
Or in my memory. I'm normally pretty good about writing down when the court makes an offer that is alternative to my own.
I'm usually pretty good about making a note as well.
And I don't remember us having a plea conference ever with this case.
That's also.
Yeah, so that's why I was very confused. Me and him, he does speak English, but there is a bit of a language barrier. And so
Okay.
this might need to be reset. He wouldn't be getting out today anyways, but he's in the quarantine pod too as well.
Makes sense.
All right, maybe a new point anyway. All right, we're going to reset Mr. Lorenzo Montanez for next Friday, December 18th. And if you can get with him, I don't have any note, which I generally create when I do make a plea offer. So if you can clarify with him as to when, at what court proceeding he thinks that occurred, you can review the audio from the court proceeding. And
Yes, Your Honor, I can do that. I think the only hearing this could have been would have been the violation of probation status hearing on Tuesday, but he wasn't even present for that. So. I don't know. But I'll do that, sir.
it may go back to the arraignment on the new charge. I don't know, but see if you can find out from him when he thinks he heard that.
Okay, yes, it might have been at the arraignment, yes. Thank you.
All right, thank you. All right, your next case.
The last one that I have is Vega Rodriguez, 20 CF 109. There are two county court pleas on there as well. And we were waiting to hear back from Judge Jansevich, but she's doing e-duty today. So I don't know what the court would want to do with that. And if we get out of jail today with all the pleas, his next court date in county court is December 23rd.
Okay,
So,
hold on. Yeah, Judge Jansevich is not available, so we can do our case. I can't do her cases today without representation that she agrees to that. So I have to leave those to either be resolved.
Okay, I'll leave that to the misdemeanor frame. Sir, Ms. Cooper will be with you about your other two cases, but we'll get this one taken care of, so there's not a hold up for that. Is that what you want to do, or do you want to? Okay, Mr. Vega Rodriguez, we cannot take care of your county court cases today because Judge Jansevich is unavailable right now. So we can either take care of your felony case today and leave the county court cases, or we can wait till those get done and take care of this at a later date. Okay.
All right. Mr. Vega Rodriguez, if you'll please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give will be the truth, whole truth, and nothing but the truth?
Yes.
All right. Please tell us your name, sir. Mr. Vega Rodriguez, in case 20 CF 109, you were placed on probation for resisting an officer with violence, which is a third-degree felony punishable by up to 5 years state prison, up to 5 years probation, and/or a fine of up to $5,000. Do you understand?
Yes.
And Judge, I'm just modifying a score sheet to remove those extra charges, since we won't be here.
So what's, excuse me, council approach for a minute. Okay.
Especially with the county court case still outstanding, I think that's appropriate.
Okay, thank you. All right, Mr. Vega Rodriguez, the court just indicated to your lawyer and the prosecutor, I could not go along with the agreement for reinstatement based on the allegation of new crimes being committed while you're on probation. So at this time, I'm just going to reset this for a violation of probation hearing on January 28th. Status hearing is January 26th. If you all want to revisit the case, perhaps plea conference between now and December 30th, I'll be happy to do that. If not, Judge Young may go along with.
Yes, I'll meet with Mr. Vega and see what he wants to do and get back with you.
All right.
Thank you.
Thank you.
Thank you.
Okay, thank you, Mr. Vega. Okay, and who else do we have remaining there at the jail?
That's Mr. Pashnot, that's mine.
Okay. 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 Oh, let me hold on to that. Yeah. All right, William Fosnot. Good morning, sir. Please state your name. Okay, Mr. Fosnot is here in case 19 CF 450. And we're here for a trial status hearing. Are we ready for trial in this case?
Yes, Judge, the state asked for the status date in order to put the offer on the record and something to that effect. I know the state also filed a motion in limine in regards to failure to call witnesses, namely potentially the alleged victim in this case. That was filed yesterday afternoon about 4 something, so I haven't had a chance to do any research into
Okay, well, that's.
for this hearing. Sorry for that.
Right. Your Honor, the state at this time is moving to continue the case or at the very least reset it to the next week of the trial period, which I believe is January 4th. The state did have good victim contact, good victim communication. The victim was prepped for trial prior to the pandemic. I've been trying to reach the victim for the past, 2 weeks since we last were here on the case. His phone number is still working, his voicemail is still working. Everything appears to be going through, but he has not returned my calls. So I don't know what's going on. I've asked an investigator to go out to his home today to figure out if he's still there, if he's okay. I don't know what the situation is. The defense has had, I believe, 3 continuances on this case in the past. I do recognize that Mr. Foshnot's in custody. That's why I'm not asking for a full continuance, just a continuance to the next date, next week of the trial period to get the victim here. If the victim does not come, I anticipate that I will amend the information to an offense or offenses that can be proven without the victim's presence. If I do that, I assume the defense and the state will want to address potential Crawford issues with the court prior to selecting a jury in the case. There's a 911 call, there's body cam that I believe, and of course photos and medical records that I all believe can prove this case without the victim's presence. But those are issues I think we'll need to work out prior to the jury being selected. So I think it is best to reset this until at least that January 4th trial date, if not in full continuance.
Okay, now saying the defense objects.
Yes, Judge, I know the court's likely, I don't want to speak for the court. The court is going to grant it. I guess my only potential issue, like I'm fine with leaving it in the trial period, and I don't want to necessarily give Mr. Baird a deadline, but if he is going to file an amended information and we're going to address those things, I don't want it to affect completely my trial preparation and then I'm having to re-prep a trial a couple days before. So if we can leave it during this trial period, and then I guess if he does potentially amend the information, then from that point, we can just roll it to the next PPC, should that pose an issue in my trial prep. That would be, I guess, the defense's position to not just go ahead and continue it now, especially if it's still going to be the result and if the information is filed.
All right. I will grant the state's motion to reset the case for trial within this trial period. We'll set it for trial January 4th. Now, Mr. Barrett, I would expect that before the end of the year, you would make a determination as to whether or not you're going to be filing an amended information.
Yes, sir. And like I indicated, I've asked our investigator to go out to Mr. Reyes' the victim's home today and see what's going on, because I honestly have no idea. We have really good communication with him prior to the pandemic shutting everything down. And like I said, his voicemail still works perfectly normal. So we're going to send someone out there. If I don't hear back from the investigator by the end of, I would say, next week, then I would anticipate that I'll be filing that amended information and going forward without Mr. Reyes' testimony. And I do believe that in good faith, based on a 911 call as far as we can, that I do not believe runs off the property.
We'll cross that bridge when we get to it, if we get to it. So, Mr. Fasnacht, your case remains set for trial. The trial date is going to be moved to January 4th. Your attorney will be in touch with you, sir. Thank you.
Thank you, Judge.
Thank you. Okay, as to Eugenia Alone, is he in custody?
No, Your Honor. I do not
Okay.
believe so.
Okay, well, apparently he was not available today because he's got quarantine issues. So I'm going to reset that case for a determination of counsel hearing on December 30th at 8:30. Okay. Do we have any other folks at the jail? Are they bringing any other folks in, or the remainder unavailable?
Yes, sir. I still have 4 here, and I have another group that's coming.
We got 4 there now. I don't see, okay.
They haven't been seen. Your names?
Yeah, that would be helpful.
Smino Max,
Okay.
and Ortiz Iris,
Okay.
Pierre Lewis, Clement,
All right.
and we have Smith Amy.
Okay, thank you. All right, are we ready on Mr. Suarez? You ready on your case, sir? You with us again?
I'll be back.
I think
He's in the lobby again, okay. I can hear that. That's not off to a good start already. Mr. Suarez, we're having huge feedback with you.
Okay, now are we good now? Still?
Yes. I think we're gonna have to reset this case. I'd prefer to do it in person anyway. Given the fact your client needs the Creole interpreter and, are you available next Friday?
Yes, I would be, yes.
Okay. Why don't we-
Are there any other dates potentially? I might not be available next Friday, just due to the nature of the case and the hearing. If he did wish to enter a plea, I'd like to be present.
Okay, we could do it the following Monday, December 21st, or Tuesday, the 22nd.
The 22nd would be preferred, Your Honor.
Are you available, Mr. Suarez?
Oh, I'm sure I would be in the 22nd, yes.
Okay. And we'll direct it, Pierre. Let's see if I can
Pierre
find it.
Luis.
Yes, Mr. Pierre Luis be physically brought from the jail on December 22nd. So we'll have him physically here. Hopefully you'll be physically here, and we'll have the interpreter either here or by phone.
Yeah, he should be ready here because I'm going to be making a motion for withdrawal, so yeah.
Okay. All right. Thank you, Mr. Suarez.
Thank you very much, Your Honor.
So we won't need Mr. Pierre Louise. Max Esperance, did you say?
Yes, sir.
Okay, Mr. Esperance, if you'll come forward. Morning. State your name, please. Mr. Esperance, you are here for arraignment in case 20 CF 3148. You were placed on, you were charged in this case with delivery of cocaine within 1,000 feet of a park. That is a a first-degree felony punishable by up to 30 years state prison. It does carry a mandatory 3-year prison sentence if you were found guilty as charged, as well as the possibility of probation for any period of time between the 3-year mandatory minimum and the maximum of 30 years that is not imposed as a state prison sentence, and a fine of up to $10,000. Do you understand what the charge is, sir?
Yes, sir.
Okay.
Can I say something on it?
You can. It's probably in your best interest that you not talk about the facts of your case. You are represented by the Office of the Public Defender. Yes, sir?
From 2 years old to 17 years old, my left hand, I used to take exam to the research. On October 21st, I was at ODC, Officer Outreach Research. I had about $7 in my pocket, $139.
Okay, Mr. Esperance, let me stop you for just a moment, sir. Let me stop you for just a moment, please listen. Mr. Esperance, we're not going to have your trial this morning. You are represented by the Office of the Public Defender. It is very likely not in your best interest to say anything to the court at this time. Anything that you do say could be used against you later if your case goes to trial. I would suggest that you tell your lawyer everything that you're trying to tell me. You may very well have a valid defense to these charges, or you may not be guilty of the charge. I don't know. The purpose of the hearing today is just to inform you of what the charge is.
I was charged with possession of cocaine and marijuana, but I did not have marijuana around me.
Judge, if I may, Mr. Esperance.
Yes, sir.
I am your attorney. My name is Richard Mendoza. Please do not say anything further because it is recorded. I will discuss, sir, let me finish. I will discuss this case with you and call you on the video or see you personally very soon.
Okay, sorry, sir, because that time nobody comes to me and they just bring me. I've been here for 52 days, they just bring me in.
Okay, well, we'll discuss your case with you, okay?
I understand your lawyer will be working on your case, Mr. Esperance. I just don't want you to jeopardize your legal situation by saying something that may not be helpful for you at this time. Make sure you tell your attorney everything about your case. Okay, Mr. Mendoza?
We'll enter a plea of not guilty at this time, Your Honor.
I will accept the plea of not guilty. Mr. Esperance will be set for trial. I'll go ahead and set it at this time for February 1st trial period. Pre-trial will be January 20th.
Yes, sir.
Thank you.
Thank you. Mr. Esperanza, I will talk to you very soon, okay?
Sir.
Hold that question, please.
I had to have a job because like I've been in for 52 days, they give me a leave to go home after it.
Okay, Mr. Esperanza, I will speak to you later today on the video, okay?
Thank you, Mr. Esperanza.
Thank you.
Amy Smith? Good morning, state your name. Ms. Smith, you're charged in case 20 CF 715 with fraudulent use of personal identification information in count 1, in possession of an unauthorized driver's license in count 2. Each of those 2 charges is a third-degree felony punishable by up to 5 years state prison, up to 5 years probation, and/or a fine of up to $5,000. Do you understand?
We'll enter a not guilty denial. I don't know.
Not guilty.
Thank you.
Sorry, I thought it was out of custody.
We'll accept the plea of not guilty. The case will be set for the March 8th trial period, pretrial February 24th. Thank you, Ms. Smith. If you have a bond in your case, you absolutely can bond out.
Ms. Smith, I'll contact you soon if you're still in jail. Okay, good luck.
Okay, and we had another person that announced, so is anyone keeping track?
Ortiz?
Oh, that's right. Iris Ortiz, Your Honor.
Okay, thank you, that's right.
In custody?
Iris Ortiz.
He's in custody?
Yeah.
Morning, tell us your name. Ms. Ortiz, you are here today in 2 cases. In case 16 CF 2586, you were placed on probation for aggravated assault. Let me double check here. All right, you were placed on probation for aggravated assault and aggravated fleeing or attempting to elude a law enforcement officer causing injury or damage. And in case 19 CF 2583, excuse me, you were placed on probation for tampering with physical evidence and possession of cocaine. In each of these cases, it is alleged that you did willfully violate your probation as follows. It's alleged you violated condition 1 by failing to report to the probation office via phone on May 4th of 2020 at 1:00 p.m. as instructed. It's alleged you violated condition 3 by moving from your last known residence at 318 East Main Street in Avon Park, Florida, on about May 1st of 2020 at 7:40 p.m. without prior approval from your probation officer. It's alleged you violated condition 9 by failing to comply with the instruction of your probation officer to comply with community control conditions. And it's alleged you failed to enter and successfully complete the Hogar Race treatment program by being discharged from that program on May 1st of 2020. You understand what the allegations are? I'm sorry? Thank you.
Will enter a denial, Your Honor.
I will accept the denial of the violations of probation or community control. Set the case for a violation of probation hearing on January 28th. Status hearing will be January 26th. Ms. Ortiz, Ms. Hernandez, or another lawyer from her office will be in touch with you shortly to discuss your options with you. Thank you. Okay. Sorry? Okay. Thank you. Is your client in custody or out, Mr.?
Your Honor, I just got hired yesterday. Mr. Harden's in the hall for a status council.
Excuse me.
Elijah Harden.
Yes.
I got hired yesterday, and we would be asking for a continuance. The state has no objection.
Okay.
I would have to do depots, but there are only 3 police officers, so it's not
fine.
Like we're asking for a ton of time.
State, did you wish to be heard? Okay, just a minute. I'm dealing with something here first. Thank you. State, did you have any objection to the motion to continue?
No, Judge, I spoke with defense. They were just retained, and there appears to be a matter that may be dispositive to the case. So
Right.
I think it continues to be prudent.
I'll grant the motion to continue as to Mr. Harden's cases, Madam Clerk, which are 19 CF 4092 and 19 CF 4287. Those cases will be set for trial during the trial period, which will begin on March 8th. Pre-trial will be February the 24th.
Judge, I believe,
And are you moving to withdraw?
I was gonna do 2 things. One, I believe counsel was only hired as to my case. He has a
Oh.
second case that I don't believe he was hired on. And he mentioned depositions. I've done depositions, so I can provide the discovery and
This case,
and
okay.
everything to him.
Okay.
Fine, Your Honor, I was only.
So which case are you hired on, Mr. Tamarkin?
I was hired on
19 CF 4092, Judge.
Okay, 19 CF 4092, the motion continues granted, set for March 8th, pretrial February 24th. Mr. Tamarkin, he also has another case, which is 19 CF 4287.
Yes, that's me, Your Honor, Zarina Hernandez Defense. I as well move to continue the case. I'm still in negotiations with the state, and we could just track both cases. That would.
Any objections, State?
There's no objection.
Okay, so I'll grant the motion in that case as previously indicated, set for the March trial docket, March 8th trial docket. Pretrial will be February 24th. Actually, pretrial in your case is February 23rd, Mr. Tamarkin. And
I'll check on the case. I wasn't aware of that. I may or may not be handling.
Ms. Smith, you're orally moving to withdraw on 4092.
Yes, Judge, that's fine, and I'll follow it up with a written.
Okay, well, thank you. Excuse me. All right, sir, if you want to come on up, is the gentleman here? We could address whoever you have on the front row there.
Yes, that's inmate Thomas.
Okay. State your name, sir. Okay, there we go.
Zarina Hernandez Defense.
All right, Mr. Sanchez, raise your right hand. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, nothing but the truth? And I'm sorry, state your name again for the record.
Thomas Junior Sanchez.
Okay. Mr. Sanchez, you're here at this time in 3 cases. In case 20 CF 2375, a plea form has been submitted which indicates you wish to enter pleas of no contest to burglary of a structure as charged in count 1 and to criminal mischief as charged in count 3. Is that what you want to do?
Yes, sir.
And state you'll be non-prosecuting count 2?
That's correct, Your Honor.
Okay. In case 20 CF 1886, a written plea form has been submitted which indicates you wish to enter a plea of no contest contest of burglary of a structure is charged. Is that what you want to do in that case?
Yes, sir.
Okay, and in case 20 CF 1936, a plea form has been submitted indicating you wish to enter a plea of no contest to possession of a controlled substances charged in count 1. Is that what you wish to do?
Yes, sir.
And say you'd be in all process in count 2?
Correct, Your Honor.
Okay, Mr. Thomas, both of the charges of burglary of a structure, as well as the charge of possession of a controlled substance to which you've indicated you wish to plea, are third-degree felonies, which are punishable by up to 5 years state prison, up to 5 years probation, and/or fines of up to $5,000. Do you understand?
Yes, sir.
The charge of possession of a controlled substance also carries a mandatory 6-month driver's license suspension. Do you understand?
Yes, sir.
The charge of criminal mischief is a misdemeanor, which is punishable by up to 60 days in the county jail, up to 6 months probation, and/or a fine of up to $500. Do you understand, sir? Do you understand?
Yes, sir.
All right. Did you read and understand the written plea forms?
Yes, sir.
Do you have any questions about anything on the written plea forms?
Oh, yeah.
Are you under the influence of medication or other drugs or alcohol at this time?
Oh, yeah.
Are you thinking clearly?
Yes, yeah.
Did any person coerce or force you to enter these pleas?
Oh, yeah.
The recommendation in case 20 CF 1886 is that you would be adjudicated guilty, sentenced to the time that you've served, followed by 24 months supervised probation. You'll be required to complete an impulse control class. You'll be required to submit to a substance abuse evaluation, follow through with any recommended treatment. You'll be required to complete 100 hours of community service. You would not return to the location of the offense or have contact with the alleged victim. You'll be required to pay $850 in restitution to Honey Whittington. There will also be a fine, court cost, public defender lien, and application fee. Is that your understanding?
Yes, sir.
Okay, in case 20 CF 1936, the recommendation is that you be adjudicated guilty, sentenced at the time you serve, followed by 24 months probation, again with impulse control and drug offender treatment, a requirement that you complete the 100 hours of community service. It is contemplated just 100 total hours, is that correct?
That's correct, Your Honor.
Okay. Your driving privileges would be suspended for a period of 6 months. You'd be required to pay a fine, court cost, public defender lien, and application fee. Is that your understanding, sir?
Yes, sir.
And finally, in case 20 CF 2375, again, you'd be adjudicated guilty of both counts to which you were pleading. As to count 1, you'd be sentenced to the time that you've served, followed by 24 months supervised probation with the same terms and conditions. There'll also be no contact with the named victim, no return to the location of the offense. And count 3 would be adjudication of guilt and time served. Is that your understanding?
Yes, sir.
Yes.
I'm looking at the email of the state, and there was a condition I failed to include on the on the plea form, and it's order and reserve restitution to the smoke shop. In that case.
Order and reserve?
Reserve restitution.
Okay, so it'd be restitution ordered. Do you understand? Do you understand that, Mr. Sanchez?
I didn't hear that.
In the last case we were talking about, I would also order that you pay restitution, reserve jurisdiction to determine the amount of the restitution. You understand?
Yeah, I understand that.
All right. Are you satisfied with your lawyer?
Yes,
Do you believe it is in your best interest to enter these pleas?
Yes, I do.
You understand that if you are not a United States citizen, entering these pleas will subject you to deportation. If you are at any time sentenced to state prison in Florida, and if you have ever previously been convicted of a sexually motivated or sexually violent crime, once you complete any sentence the court might impose, you could be committed civilly for an indeterminate period of time as a sexually violent predator. Do you understand?
Yes, Your Honor.
Excuse me. You have the right in each one of these three cases to have a jury trial to determine whether the state can prove that you committed these crimes. If you chose to go to trial, at each of your trials, you would be presumed to be innocent. You could not be found guilty of any crime unless a jury unanimously found the state had proven your guilt beyond a reasonable doubt. Do you understand?
Yes, Your Honor.
You would have the right at each trial to be represented throughout your trial by Ms. Hernandez. You would have the right to confront and cross-examine witnesses who testified against you. You would have the right to present witnesses and evidence in your defense. You're entitled to use of the court's subpoena power to require any witnesses you may have to be present at your trials. You also have the right at trial to testify yourself. Or you could choose to remain silent, and if you decided not to testify, you have the right to have the jury instructed. They could not consider the fact you chose not to testify as evidence of guilt. Do you understand?
Yes, Your Honor.
By entering these pleas, you're giving up the rights we've just talked about, as well as the other rights that are written on the plea forms, and there won't be a trial in any of your cases. You also, by entering these pleas, are waiving your right to appeal any matters relating to your cases other than the jurisdiction of this court to hear your cases and the legality of these sentences imposed. Do you understand?
Yes, Your Honor.
Okay. All right, Mr. Sanchez, I've read the arrest affidavits and affidavits for arrest warrants in these three cases. Based on those affidavits, I find in each case that there's a factual basis upon which your pleas can be accepted. I find that you are alert and intelligent, that you understand the nature of the charges against you, you understand the penalties that you're facing, as well as the rights that you're giving up by entering these pleas, and finding your decision to enter the pleas has been freely and voluntarily made, that you've had the advice of competent counsel with whom you've expressed satisfaction, so I'll accept the pleas of no contest. Ms. Hernandez, you agree with the score sheet of 29.8 points.
Your Honor, there is an error on the score sheet. We did speak at the state would like to amend the score sheet on the record. On the additional offenses on page 1, there is criminal mischief under 20 CF 1886. That's not charged in that case at all, so the score sheet is all over.
That's correct, Your Honor.
All right, I'll make the amendment. So that's the only objection?
Yes, Your Honor.
So it's 29.6 total sentence points.
Yes, Your Honor.
Okay. Madam Clerk, what's the time served in each of these cases?
The three cases?
What's the time served in each one of these cases,
Okay,
please?
for 20 CF 2375, 115.
116,
115.
15, okay.
For 20 CF 1936 is 120. And for 20 CF 1886, 120.
Okay. All right, Mr. Sanchez, in case 20 CF 1886, court will adjudge you guilty of burglary of a structure. You'll be sentenced to 120 days in the Osceola County Jail with credit for 120 days time served. I'll be followed by 24 months supervised probation. It'll be a condition of your probation that you complete 100 hours of community service at the rate of no fewer than 8 hours every month, beginning no later than the second month of your probation. You're ordered to pay court costs of $415, a $100 cost prosecution, a fine of $500, $100 public defender lien, $50 public defender application fee, restitution to Honey Whittington in the amount of $850. All of which is paid to be paid at the rate of no less than $50 every month, beginning no later than the third month of your probation. If any money remains unpaid when you complete probation, it's ordered to be paid through the clerk's collection program at that same rate beginning the first month following termination of your probation. You're not return to the area of 1308 North Levon Avenue, Kissimmee, Florida, while on probation. You'll be required to submit to a substance abuse evaluation within 30 days and follow through with a recommended treatment. You are ordered to report to the probation office no later than 2:00 p.m. on Monday, December 14th. You'll be required to submit a biological specimen for inclusion in the Florida Department of Law Enforcement DNA database. In case 20 CF 1936, you are judged guilty of possession of a controlled substance as charged in count 1. Sentenced to 120 days in the county jail with credit for 120 days time served, followed by 24 months of supervised probation. Be required to attend and complete an impulse control class. If I did not mention it, that's a condition in the first case as well. The impulse control class will be done within 90 days. You'll be required to submit to a substance abuse evaluation within 30 days and follow through with a recommended treatment. It'll be a condition of your probation that you complete the 100 hours of community service ordered in case 20 CF 1886 within the time period ordered in that case. You're ordered to pay court costs of $415, a $100 cost prosecution, a fine of $250, $100 public defender lien, and $50 public defender application fee. Excuse me. At the rate of no less than $50 per month, consecutive to the payments ordered in case 20 CF 1886. Your driving privileges are ordered suspended for a period of 6 months. The court has no objection to obtaining a business purposes license if you qualify. In case 20 CF 2375, you are judged guilty of burglary of a structure as charged in count 1, and criminal mischief as charged in count 3. As to count 1, you'll be sentenced to 115 days in the county jail, cut for 115 days time served, followed by 24 months supervised probation. Probation will run concurrent with the probation in cases 20 CF 1886 and 20 CF 1936. As to count 3, you'll be sentenced to 60 days in the county jail with credit for 60 days time served. It'll be a condition of your probation that you submit to a substance abuse evaluation within 30 days, follow through with a recommended treatment, that you attend and complete an impulse control class within the first 60 days of probation, that you complete the 100 hours of community service ordered in case 20 CF 1886 within the time period ordered in that case. It'll be a condition that you not return to the smoke shop at 3123. You do not return to this smoke shop at 5347 West Earl of Bronson Memorial Highway. You were to pay court costs of $415, a $100 cost prosecution, a fine of $500, $100 public defender lien, $50 public defender application fee. I will order restitution to Hamid Mikach or the smoke shop and reserve jurisdiction to determine the amount of the restitution. The monies ordered to be paid at the rate of no less than $50 per month consecutive to the payments ordered in case 20 CF 1936. Again, any monies not paid during the period of probation are ordered to be paid through the Clerk's Collection Program at that same rate beginning the first month following termination of probation. You'll be required to submit a biological specimen for inclusion in the Florida Department of Law Enforcement DNA database. You are required to report to the probation office in all three cases no later than 2:00 p.m. Monday, December 14th. Is there anything further with respect to the sentences?
We waive PSI.
Oh, thank you. I didn't. So we'll note that PSI was waived. Mr. Sanchez, you have 30 days within which you can appeal the judgments and sentences that were just entered. If you wish to appeal and you cannot afford to hire a lawyer, I will appoint one to represent you. If you do not file a notice of appeal in writing within 30 days, you waive your right to appeal. Do you understand?
Yes, Your Honor.
All right, thank you, sir.
Yeah, one more thing. I did, when I gave the clerk the list of cases to
Right.
be out today, one of them was a misdemeanor case.
Right.
I just didn't have a plea form for it. Is that
Okay.
something we could still do?
No, let's do a plea form, and maybe the county judge will do it without it, but,
Okay, I'll just let Mr. Sanchez know he still has bond on that misdemeanor if he wants to
Okay.
get out. Oh, that's not even.
all right, thank you. Okay, we have a couple more jail cases.
Your Honor, I'm sorry.
Yes, sir.
Interrupt here.
Yes, sir.
This is Attorney Robert Zlack, and the reason I'm interrupting here is because I was asked by the ASA assigned to this case. I know she has out-of-county depositions.
Which case
so
are
I
we
wanted to
talking
see-
about? What is this case?
Your Honor, it's Miss Lowe.
Malika Lowe, Your Honor.
Okay. So this is case 20 CF 3437. And looks like Ms. Lowe may be present via Teams. So what are we doing in this case?
She is, Your Honor. Your Honor, we have, defense has filed a motion in this case. Ms. Lowe, as part of her release conditions, was required that she not to return to her current residence. She is the sole owner of that residence. So we had filed this motion. We're not necessarily asking, I guess, to kick the victim out of this residence. But if that's the case, we would certainly not, we're seeking to have her in some way return to her home, Your Honor.
All right. State?
Yes, Your Honor. Lauren Demers on behalf of the state. And for the record, I do have the victim, Mr. Davey, is present on Teams, as well as his attorney that he has hired, Mr. Singh. They are both present. The state does object. I can elicit testimony from Mr. Davey if the court would like, but it is my understanding he does not wish to have Ms. Lowe return home. He does not want contact with her. And it's my understanding that an injunction is being filed and he is scared to have her return home. And if Your Honor wants, I can elicit more testimony. So the state.
Your Honor, Michael Singh.
Yes,
Michael
sir.
Singh, I'm counsel for the victim.
Right.
The injunction was actually approved yesterday. We filed it. It was approved yesterday evening.
So there's an injunction prohibiting contact. The defendant is accused of attempted murder of this person. Why would the court consider allowing her to return to the residence?
Your Honor, I would state simply that Ms. Lowe is, again, the sole owner of this.
Right. Well, ownership's not an issue at this point. I understand. I said ownership is not at issue at this point. That's not the court's concern at this point. It's the safety of the occupant.
Well, our position would be that, he does not, again, I think that ownership does play at least some role in here because Ms. Lowe would have the authority if that he would be, he's an unlawful resident of that occupant at this moment, of this residence at this moment. I mean, she would have every right if he were to file an unlawful detainer to have him removed from the residence. So, he doesn't pay rent, he doesn't pay anything. His only ownership in the his only reason to stay in the property is based on their relationship.
Understood. Unfortunately, this.
They're not married, Your Honor.
I'm sorry, that's fine, but this is not an infrequent situation in cases of alleged domestic violence, and the court doesn't kick an alleged victim out of the residence that he or she has been living in because he or she has become a victim of domestic violence. Whether or not Ms. Lowe is entitled to rent or is entitled to proceed with civil eviction proceedings is a whole different thing or a whole different matter, but I'm not going to order that Mr. Davey remove himself from the property at this time. So I'm going to deny the motion to modify the no return order at this time. Thank you, folks.
Understood, Your Honor. Thank you.
Thank you. Okay, who else do we have in the jail? Morning, sir. What is your name?
Mr. Leputko, sir.
Okay. Yes, sir. Mr. Leputko, you're here for arraignment in case 19 CF 2148. You are charged in this case with possession of a controlled substance in count 1 and possession of drug paraphernalia in count 2. Count 1 is a third-degree felony punishable by up to 5 years state prison, 5 years probation, and/or a fine of up to $5,000. Count 2 is a misdemeanor punishable by up to 1 year in the county jail, 1 year probation, and/or a fine of up to $1,000. Do you understand what the charges are?
Yes, sir.
All right, Mr. Leputko, your attorney, I believe, is present in the courthouse, but is in another courtroom that we don't have video communication with at this time. But I'm going to enter a non-prejudicial plea of not guilty on your behalf at this time and set the case for the March 8th trial period. Excuse me. Actually, based on the date of arrest, I'm going to set it for the February 1st trial period. Pre-trial will be January 19th. Mr. Zaleski or another lawyer from his office will be in touch with you very shortly. You may, based on the nature of these charges, be able to resolve this through the state attorney drug diversion program or through the drug court program. If you wish to do so, you can talk to your lawyer about that. Thank you. All right, thank you. All right, and we have, if we can bring up whoever's, just bring up whoever's close by, if we have someone left.
We have two right coming from the pot.
Oh, they haven't come in yet, okay.
Your Honor, while we wait, can I address a couple of clients that are in custody in another jurisdiction?
Sure.
Devontae Miller. He's in Seminole County.
Okay. I don't see him on, oh, there he is, okay. So Mr. Miller's in Seminole County. excuse me, we'll reset him for arraignment on December 29th at 8:30, and say if you do a transport order, we'll see if we can get him here.
You said December 29th?
Yes.
No problem.
And there's.
Good morning, Your Honor. Jose Torrey. I just have a PTD status, CDP status.
Okay, just a moment, sir. We're addressing another attorney right now. Yes.
I lost my place on the docket, Your Honor.
Okay. Now, Ms. Toro, yes, sir. Who do you have?
I have Rafael Alayon Perez, Your Honor, my client, and I have signed the contract. We're just waiting for the state to sign it. This is Miss Castro, so we signed it on November 23rd, and I've been emailing it to Miss Castro, who is the one that appears as the state attorney.
I'm sorry, what's your client's name?
Rafael Alayon Perez. Alayon with an A dash Perez with a P.
Yeah, I don't see him on my docket. Do you have a case number?
Not with me, Judge. Rafael Alayon Perez. I don't have it readily available, the case number. But it was said, Your Honor said for this, just to make sure that the contract was signed.
It's case 20 CF 761.
Okay. I don't have it.
Alayon, A-L-Y-O-N. You don't have it?
Well, the first one I have is Albright. You're here. That's a problem. Okay. So what's the case number again?
20 CF 761.
All right.
All we need is for the state to sign the contract.
I understand what you're saying, Ms. Torway. I just have to pull up the case. Who's the state?
Ryan Hagan, the state.
So, I see a drug diversion level 2 contract, so it sounds like we need a status hearing date.
Correct.
All right, Ms. Torway, I'm going to set this case for a status on January the 22nd at 8:30. If your client completes everything, gets the money paid, just get with the state. They'll file a null process prior to that. Otherwise, we'll see what's going on at that time.
Thank you, sir.
Yes, thank you.
Thank you. Nice weekend, sir.
You too.
Judge Matt Olszewski, I have the exact same thing that Mr. Torriello had on Julianne Keller Webb.
Okay. All right, so this is a state attorney drug diversion program, is that correct?
Yes, Your Honor.
And has the contract been signed?
I believe we have it signed. I think we just got to send it over to Your Honor for the $100 to go in the system. Okay. And she completed the wrong class, so she just has to watch the class. But I believe the $100 has already been paid.
Okay, well, I don't get involved in the payment and stuff, so I'll set up a status hearing on January 22nd as well, and that should give you plenty of time to get everything done and before it comes up. Julianne Keller Webb. All right, thank you, Mr. Olszewski.
That'll work, thank you, sir.
Thank you. All right, we got 2 more folks at the jail. If you gentlemen in the front row, if you'll come on up. What is your name, sir?
You'll need an interpreter, Your Honor.
Okay, it's Jose who?
Torres Caraballo.
All right.
Morning, Your Honor. This is the Creole interpreter.
Okay, actually, I need the Spanish interpreter. Should I call back?
Hello, Your Honor. Can you hear me?
Yes, did you say this is the Creole interpreter?
This is a Creole interpreter, Your
I
Honor.
was calling for a Spanish interpreter. Should I hang up and call back?
Yes, please, hang up and call back.
Thank you.
Good morning, Your Honor. This is Theodore Leal, Spanish interpreter. The interpreter has been previously sworn, Your Honor.
All right, Mr. Leal, we are here in case 14 CF 729 for a arraignment on a violation of probation. The defendant's name is Jose Antonio Torres Caraballo, and we're seeing him via video link up from the jail. Mr. Torres Caraballo, if you'll state your name, please. Mr. Leal, he does not have the headsets on.
Señor Caraballo, si da su nombre, por favor. José Torres Caraballo.
Mr. Torres Caraballo, you were here for arraignment on a violation of probation.
Señor Torres Caraballo está aquí para que se le dé lectura de cargo por una violación al régimen de prueba.
You were placed on probation for aggravated stalking.
Usted estaba bajo régimen de prueba por acecho agravado.
You've been accused of violating your probation.
Y se le acusa de que usted quebrantó su término de régimen de prueba.
It's alleged that you violated Condition 5 by committing the offense of grand theft of an automobile.
Se presume que usted quebrantó la condición número 5 del régimen de prueba por estar involucrado en el hurto de un vehículo, hurto mayor.
On May 5th of 2017 in the Bronx, New York.
And this did in New York.
It's alleged you violated Condition 5 by committing offensive forgery of a Florida driver's license on that same date at the same place.
Y en esa misma fecha y en ese mismo lugar también se quebrantó esa condición 5 por falsificar una licencia de Florida.
It's alleged you violated Condition 3 by leaving Orange County, Florida, and entering New York on or about May 5th of 2017 without permission.
Y también se presume condición número 3, al trasladarse del condado de Orange a Nueva York, en contravención a su régimen de prueba el 5 de mayo de 2017.
It's alleged you violated Condition 2 by failing to pay the cost of supervision as ordered.
También que se presume que violó la condición número 2 al no pagar los costos de supervisión como se le ordenó.
It's alleged you violated Condition 3 by moving from your last approved residence on or about March 17th of 2017 without approval.
Y también la condición número 3, en la que usted se cambió de la residencia en la que estaba previamente aprobada, más o menos en la fecha 17 de marzo del 2017, sin haber obtenido permiso.
It's alleged you violated Condition 10 by failing to pay the restitution as ordered.
También se presume que violó la condición número 10 cuando no hizo el pago de daños, tal como se le ordenó.
It's alleged you failed to complete the substance abuse treatment as ordered.
También que usted no culminó con el tratamiento para abuso de sustancias como se le ordenó.
It's alleged you failed to complete the batter's intervention program as ordered.
Y también que usted no culminó con el programa para maltratadores que se le ordenó.
You understand what the allegations are?
¿Entiende qué es lo que se está señalando?
Sí, entiendo, pero yo no falsifiqué una licencia.
Okay.
Excuse me, my question is only if you understand what the allegations are, not whether you're guilty or not at this point.
Sí, lo que estoy preguntando es nuevamente si usted entiende las acusaciones que está haciendo. A esta altura no estamos lidiando con lo que es culpable o no culpable, sino que sí entiende. Yes, correct.
I want to stand denial, Your Honor.
Excuse me. I will accept the denial of the violation.
Acepto la negación que ha interpuesto la abogada.
And Ms. Torres Caraballo, you may very well have a you very well may not be guilty of these allegations. I'm just telling you what you've been accused of.
Señor Torres Caraballo, usted puede que usted no sea culpable de esas acusaciones que se le están haciendo.
If you have a defense to any or all of these allegations, you need to discuss that with your lawyer, but it's not in your best interest to talk about it right now in court.
Si usted tiene pues defensa que presentar, usted tiene que conversar con esa defensa con su abogada, pero no le conviene de momento hablar de nada al respecto mientras estamos aquí en la sala del tribunal.
Now, you had filed an affidavit saying that you had take-home income of $1,600 per week.
Usted llenó un affidavit diciendo que ganaba $1,600 por semana.
Are you earning any money while you're in jail?
Mientras está en la cárcel, ¿usted está ganando dinero?
No.
No.
Do you have any money in the bank right now?
¿Tiene dinero en el banco en estos momentos?
Sí, mi señora está trabajando.
Yes, my wife is working as well.
Okay. Do you know approximately how much money you have in the bank?
¿Sabe aproximadamente cuánto dinero tiene en el banco? I have about 5,400.
Have you tried to hire a lawyer?
¿Usted ha intentado contratar un abogado?
No, pero estoy pensando, mi familia me quiere ayudar y estamos pensando contratarlo.
No, but I've been thinking about it, and my family wants to help me out, and we're thinking about hiring one.
Yeah, I'm afraid that based on the money you have in the bank, you don't presently qualify for court-appointed counsel, so I'm going to I'll keep the public defender's office provisionally appointed while you're in jail until another lawyer is hired, but you cannot, you'll have to hire another lawyer.
Entonces yo me temo que debido al ingreso que tiene, usted no calificaría para que se le asigne un defensor público, pero voy a mantener de todas maneras a la Defensoría Pública a cargo de su caso mientras usted está en la cárcel y hasta que contraten a otro abogado que usted tendrá que contratar.
So I'm going to accept the denial entered by the public defender's office and set your case for a violation probation hearing on January 28th with a status hearing on January 26th.
Entonces, lo que yo voy a hacer es que voy a aceptar la negación de la acusación presentada por la abogada de la Defensoría Pública y voy a señalar fechas para próximas vistas, una audiencia para el 28 de enero y una audiencia de revisión de estatus para el 26 de enero.
And we'll set the case for a determination of counsel hearing on January 8th at 8:30.
Y para el 8 de enero a las 8:30 sería la audiencia para presentación formal de su abogado.
And that hearing is just to see where you are in the process of getting a private lawyer on board, sir.
Y eso es para ver cómo va usted en el proceso de contratar un abogado para que asuma su defensa en este caso.
Thank you, sir.
Gracias, señor. Thank you.
If we could have the other gentleman come on up. Thank you, Mr. Hill.
You're very welcome, Your Honor.
What is your name, sir? Okay, Mr. Albright, you're here in case 20 CF 1166. And you've been charged in this case with dealing in stolen property in count 1, burglary of a structure in count 2, receiving money from a pawnbroker by false verification of ownership identification in count 3, and petty theft in count 4. Count 1 is a second-degree felony punishable by up to 15 years state prison, 15 years probation, and/or a fine of up to $10,000. Counts 2 and 3 are third-degree felonies, each punishable by up to 5 years state prison, 5 years probation and/or fines of up to $5,000. Count 4 is a misdemeanor punishable by up to 60 days in the county jail, 6 months probation, and/or a fine of up to $500. Do you understand what the charges are, sir?
Yes, sir.
Zarina Hernandez defense will enter a plea of not guilty.
All right, we'll accept the plea of not guilty. Mr. Albright, I'm going to set the case for trial, excuse me, on the February 1st trial period. Pretrial will be January the 20th. Ms. Hernandez or another lawyer from her office will be in touch with you very shortly, sir. Thank you. All right, so I believe that's everyone from the jail.
Judge, I had one on the docket, but they did not have him on the list. It's Kevin Serrano Santiago, 20 CF 853.
Okay, was that going to be a plea or?
Judge, if you recall from the other day, it seemed like he didn't understand the plea. So I need additional time to follow up on that. So can we put this back on the trial, Doc?
Good afternoon, Your Honor. This is Theodore Leal, Spanish interpreter. The interpreter has been previously sworn, Your Honor.
Good afternoon, Mr. Leal. We have in-jail initial appearances today. You'll be doing your interpreting over the intercom system. The first case that I have is Amaris David, and that's 2020 MM 2986.
Thank you, Your Honor.
Thank you. Good afternoon, ma'am.
Buenas tardes, señora. Good afternoon. Good afternoon.
Ma'am, you were arrested based on an allegation of battery domestic violence. I have taken a look at the charging affidavit, and I do find probable cause.
Señora, usted ha sido arrestada por agresión física, un caso de violencia intrafamiliar, de eso es que se le imputa, y yo le di un vistazo al escrito acusatorio y determiné que habían indicios de culpabilidad.
We have a witness present today.
Aquí tenemos hoy presente un testigo.
Ma'am, do you need the assistance of an interpreter?
Señora, ¿necesita usted la ayuda de un intérprete?
No.
No.
All right, thank you. We're going to place you under oath.
Le pondrán bajo juramento. Voy a afirmar que el testimonio que hará será la verdad, toda la verdad y nada más que la verdad. ¿Lo jura ante Dios? Sí.
Ma'am, could you tell me your name and your age, please?
Nombre y edad, por favor.
Sarah Danis, I'm 20.
20?
Yeah.
Thank you.
20.
All right, ma'am, you are alleged to have been the victim in a domestic violence incident that occurred on December 9th.
Usted presuntamente es la víctima de un caso de violencia doméstica que ocurrió el 9 de diciembre.
I am going to consider what conditions to release your mother on.
Yo he considerado las condiciones para poder liberar a su madre.
Do you wish to have contact with your mother?
¿Quiere contacto con su madre? Sí.
Have there ever been incidents of violence in the past between you and your mother?
¿Usted ha tenido incidentes de violencia en el pasado entre usted y su madre? No.
If the court were to allow your mother to return to the family home, do you have any fear of any other incidents of violence?
Si el tribunal le permite que vuelva a la casa, su madre, del hogar, ¿usted teme que hayan otros incidentes de violencia en el futuro? No.
Do you have a cell phone or a way to contact law enforcement in case there was future allegations of violence?
¿Usted tiene móvil para poder contactar a la fuerza pública en caso que haya incidencias de violencia en el futuro?
Yes.
Sí.
Are there any other children or family members in the home?
¿Hay niños u otros miembros familiares en la casa? No.
Yes.
Oh, sí, yes.
Yes.
Who's in the home?
My little sister.
¿Mi hermana?
My little sister.
¿Mi hermana menor?
How old's your little sister? How old?
She's 8.
De 8 años.
Thank you. Do you have any fear for the well-being of your little sister if your mom is allowed to come back to the house?
¿Teme usted por la integridad física de su hermanita si se le permite a su madre regresar a su casa? No.
Thank you. State, do you have any questions of this witness?
No, Your Honor.
Fiscalía.
Ms. Romero Sanchez, do you have any questions of this witness?
Romero Sánchez, pregunta para este testigo, no, su señoría.
Thank you. The court is going to release Ms. Cadavid on $250 bond plus pretrial release conditions. Those pretrial release conditions will that she have no hostile contact with her daughter, Sarah Donice.
Judge, she doesn't qualify for pretrial release as there's some immigration detainer right now.
Okay.
Lleva $250 de multa, más condiciones de libertad provisional y prohibir contacto de hostilidad con la hija, ya 12, pero no califica, su señoría, porque ella tiene una solicitud de retención a petición de inmigración.
Right. The immigration detainer is beyond my area of influence. I will set bond the amount of $250 with the condition of bond that she have no hostile contact with her daughter. She may be allowed to return to the home.
Bueno, lo que tiene que ver con inmigración ya está más allá de mi jurisdicción, pero lo que va a hacer pues, de esta parte de este tribunal es imponer $250 de fianza. Puede volver otra vez a la casa, pero se le prohíbe que tenga contacto hostil con su hija.
As far as the state of Florida is concerned, she is bondable. As far as her immigration issue, she will need to sort that out with the federal immigration authorities.
Y ya el asunto de inmigración es algo que tendrá que arreglar con las autoridades federales de inmigración, pero en cuanto a lo que es el Ministerio Público, sí ellas tienen derecho a fianza.
Do we have any additional court dates?
¿Otras fechas?
All right.
December 23rd, if sit in jail, or January 13 at 8:30 a.m. if released.
All right. You will see a judge by December 23rd if you are still in custody.
Si está todavía en la cárcel, entonces tendrá una vista ante el juez el 23 de diciembre, si está en la cárcel. Y si ha salido, entonces sería el 13 de enero a las 8:30, si acaso ha salido de la cárcel.
Thank you for your testimony, ma'am.
Gracias por su testimonio, señora.
That will complete our hearing.
Concluye la audiencia.
And if I didn't announce it, I'll appoint the Office of the Public Defender to represent.
Y decirle a la Defensoría Pública, si no lo hice antes, para que la represente.
Mr. Leal, we have one additional gentleman, and that is Eduardo Cruz Munoz.
Thanks.
Case number is 2020-MM2987.
Thank you, Your Honor.
Good afternoon, Mr. Cruz Munoz.
Buenas tardes, señor Cruz Muñoz. Good afternoon.
You were arrested based on two allegations. One is resisting an officer without violence, and the other is possession of drug paraphernalia.
Usted está acusado porque tiene dos imputaciones aquí. Una es oponer resistencia a un oficial sin violencia y el otro es tener en su poder artículos para el uso de drogas.
I find probable cause for your arrest.
Y he determinado que hay indicios de culpabilidad que justifican el arresto.
You qualify for release on pretrial release, and you will be released on pretrial release.
Usted sí reúne los requisitos para ser puesto en libertad provisional, así que lo soltaré con libertad provisional.
Two conditions of pretrial release: you may not possess or consume any illegal substances.
Bueno, las condiciones de esta liberación es que usted no puede consumir ni tener sustancias ilegales.
And you will be randomly tested for any drugs in your system at the request of your pretrial release officer.
Y se le harán pruebas al azar para determinar si hay drogas en su sistema a petición de su oficial de libertad provisional.
Public Defender's Office is appointed.
Se ha designado a la oficina de la Defensoría Pública.
Any additional court dates?
¿Más fechas de comparecencia?
January 13th at 8:30 a.m.
El 13 de enero a las 8:30 de la mañana.
Thank you, sir.
Gracias, señor.
All right, Mr. Leal, that's all the business that I'm aware of this afternoon. Thank you for your help.
You're very welcome, Your Honor.
Anthony Anselmo. Good afternoon, sir. Sir, you're with us based on an arrest for an out-of-county warrant. That warrant's out of Polk County on CF 20006-304. Judge over in Polk County issued no bond. You're going to remain on no bond with us. We'll let Polk County know you're with us and try and ship you over there to take care of the allegations. Looks like a violation of probation allegation on a grand theft offense. And while you're here with us in the jail, I will appoint the Office of the Public Defender to represent your interest. Thanks. Deanna Brinkley.
And I believe she has a private attorney.
Good afternoon, Ms. Brinkley. You anticipate getting a private attorney on your case?
Yes, Your Honor.
All right, who is that?
His name is Mike Morrison.
All right. Has Mr. Morrison filed his paperwork in your court file, do you know?
Yes, sir.
All right, thanks. You are with us based on an arrest, the allegation being you violated probation in 2019, CF 3853. The allegations are for a number of things, being discharged from transition house, violation of condition 1, failing to make an appointment, failing to carry out the instructions of your probation officer, getting behind on your court costs, and failing to comply with your probation officer's instructions, changing residences without permission, failing to report, being away from your approved residence on a number of occasions. Judge Morgan has issued no bond. You are going to remain on no bond. Mr. Morrison will get a copy of the paperwork as soon as he has formally entered your case, and you may have an additional court date with Judge Morgan, and I'll announce that now.
December 21st at 8:15 a.m. in courtroom 5F.
You're going to see Judge Morgan on Monday, the 21st, if not before. Thanks. Sandra Marie Glass.
Your Honor, she's also going to be seeking a private attorney.
Okay. Thank you. Good afternoon, Ms. Glass. Ms. Glass, are you going to be seeking private counsel on your case? No? Do you want me to consider appointing the Office of the Public Defender? All right, thank you. The Office of the Public Defender is going to be appointed on 2020 MM1579. Should you change your mind and retain private counsel, they can always substitute in for the efforts of the Public Defender. You are here based on a warrant. That warrant was signed by Judge Arendas. The warrant has no bond. You'll remain on no bond with us. The allegations in the violation of probation are that you absconded from probation and they couldn't find you. I may have an additional court date for you, and I'll announce that now.
December 23rd at 8:05 a.m. courtroom 4A.
All right, you're going to see Judge Arendas on December 23rd. Thanks. Michelle Ingram. Good afternoon, Ms. Ingram. Ms. Ingram, you were arrested based on an allegation that you missed court in 2020 MM1769. Judge, I think that was horrendous. Let me see. Judge Arendas granted you a bond in the amount of $2,999. I will appoint the Office of the Public Defender to represent your interests, and we may or may not have an additional court date for you.
December 23rd at 9 a.m. courtroom 4E.
You'll see Judge Arendas next Wednesday, the 23rd. Thank you. Jesse Jennings. Good afternoon, Mr. Jennings. Mr. Jennings, you're here based on my arrest warrant. I issued no bond, and you'll remain on no bond. The allegations are that you violated probation in your case, and that would be case number 2019 CF 4015. The allegations are failing to complete your treatment program and testing positive, I think, memory serves. Court will appoint the Office of the Public Defender to represent you. I don't know if I've got court dates indicating that I do.
On December 14th, 8:30 a.m., courtroom 4F.
I'm going to see you back on Monday, December 14th? Or is it the 15th?
14th. So that's, yes.
All right, I don't know why you'd be coming back in front of me on the 14th, but if that's the date that the clerk is showing, we'll have a conversation with you on December 14th. Thanks. That's not a VOP
We'll
date.
take that one out.
Yeah, we might have missed by a day on that one. I think my status day is on the 15th, so I may have screwed that up. Imanol Francil Jimenez Mota. Good afternoon. You have two cases with us. One is 2020 CT 2306, and the other is 2020 CT 2307. You were arrested based on Judge Arendis's warrant indicating that you failed to appear for a rule to show cause on each case. I'll appoint the Office of the Public Defender to represent you on both cases. Judge Arendis granted you a bond in the amount of $2,999 on each case and will announce any future court dates.
January 11th at 3:30 p.m., courtroom 4E.
You're slated to see Judge Arendis on January 11th. Thank you. Joseph Taylor. Good afternoon. Mr. Taylor, you were arrested based on a failure to register times 5. There's 5 counts of failing to register. Count 2 is specific to a phone, and counts 3, 4, and 5 are specific to vehicles. Taking the allegations in the, another judge, Judge Hansavich, has already found probable cause for your arrest for those allegations and issued a warrant. We do have a witness present. Is that all right? Thank you. You are Mr. Uzel?
Yes, sir.
All right. Thank you. I would advise not to give any information at this time. This is an initial appearance. Mr. Taylor is going to be appointed the Office of the Public Defender. I am inclined to grant a bond on each of the allegations. Is there any additional information you'd like me to consider?
It was just taken care of yesterday. Called and registered the vehicles and the phone number with Yolanda at the Sheriff's Department, so it's in the system and it's been taken care of.
Yes, sir. All right. The young lady to your right is an Assistant State Attorney, and I'm sure she's made a note of your statement today. Thank you very much for that information, sir.
Yes, sir.
Mr. Taylor, the court is going to grant a bond on each case in the amount, on each count in the amount of $500. Plus, does he meet criteria for pre?
He does, Judge.
Yeah, I was gonna ask.
All right, the court's going to reduce the bond down to $100 on each count and add conditions of pretrial release. You'll need to provide your information to pretrial release. There may be some requirements to report to PTR while you are pending this case getting sorted out. And I will appoint the Office of the Public Defender to represent your interests.
Your Honor, can the court consider direct PTR since he meets direct PTR?
State,
Defer the court, Your Honor.
has there been, do you have a score sheet? Has there been any previous failure to register?
I don't have a score sheet, Your Honor, unfortunately, because this was a warrant case. I have limited information. If you give me one moment, I can look it up.
We've never failed to register, Your Honor.
All right, thank you, sir. We can give the state an opportunity just to take a quick look, and then I may consider that request. Ms. Romero Sanchez.
Thank you, Your Honor.
Your Honor, I don't show any prior history of failing to register.
Thank you for that information. All right, the court's going to grant the defense's request. With that additional information, Mr. Taylor will be released on pretrial release. Mr. Taylor, you still have all of those same reporting requirements, so please be in strict compliance. And do I have any additional court dates for Mr. Taylor, or are they on demand? You'll be noticed when and if the state of Florida decides to file charges on these allegations. Thank you.
Thank you, sir.
Judson Vadrine. Thank you. Good afternoon, sir. Sir, you were arrested based on 6 violation of probation warrants in 2017 CF 875, 2017 CF 896, 2017 CF 891, 2017 CF 900, 2017 CF 856. Judge Wooten has found probable cause for your arrest and granted you a bond as to each case in the amount of $500. I will appoint the Office of the Public Defender to represent your interests, and you may have a date set with Judge Wooten.
February 4th at 9:30 a.m. in all cases.
You're going to see Judge Wooten in February. Thanks. Brian Zaring.
Your Honor, he refused.
All right. Thanks. Do you want him recalled, Ms. Romero Sanchez, on another day?
Yes, Your Honor.
All right. Thanks. We'll try again on Monday. Daniel Bertrand. Good afternoon, Mr. Bertrand. How are you doing today? Not bad. Thanks for asking. All right. So you were arrested based on my warrant, which directed the clerk to issue a capias on 2020 CF 3579. That alleges 3 counts. Count 1 is dealing in stolen property. Count 2 is receiving money from a pawnbroker by false verification of ownership or identification. And count 3 is the same allegation. 1 second-degree felony allegation, 2 third-degree felony allegations. Court has granted you bond in count 1, the amount of $1,000. As to count 2 and 3 each, your bond is set in the amount of $500. You're not allowed to return to the simple pawn. Have no contact with the victims in this case, and I will appoint the Office of the Public Defender to represent your interests. Thanks. Earl Alexander. Good afternoon, Mr. Alexander. Mr. Alexander, in 2020 CF 3601, it is alleged domestic violence battery by strangulation. I have read the charging affidavit. I do find probable cause for that arrest. I'm going to appoint the Office of the Public Defender to represent your interests in this case. Does Mr. Alexander qualify? Thank you. Ms. Romero Sanchez, do you want to ask Mr. Alexander if he cohabitates or lives in that house at Marbella Drive?
Yes, Your Honor.
Thanks.
Yes, Your Honor, he does reside in that residence.
All right, based on some of the statements that were alleged in the charging affidavit and based on the fact that I have no sworn testimony from the alleged victim, the court is going to set bond in the amount of $500 with pretrial release conditions. As a pretrial release condition, he's to have no contact with Jonelle Alexander. And for the time being, he's not going to be allowed to return and reside at 2956 Marbella Drive. As a special condition of pretrial release, he's not to consume any alcohol or illegal substances. He may return one time to the address with law enforcement to get some personal belongings while this gets sorted out, and he can petition his trial court for an amendment of the conditions of bond. Do I have any additional court dates? Nope. I don't have any additional court dates for you, Mr. Alexander. Thank you. Kevin Barlow. Thanks. Good afternoon, Mr. Barlow. I'm going to appoint the Office of the Public Defender for you. I've got two matters before me today. One is in 2020 MM 2985 and one is in 2020 CF 3607. The allegation in 2020 MM 2985 is battery, domestic violence related. I've taken a look at the affidavit. I do find probable cause for your initial arrest. Your bond in that case is going to be set in the amount of $500. Will pretrial release take him with the other offense?
Yes, Judge, with the bonds, yes.
Thanks. I'm also going to place you on pretrial release with the special conditions that you have no contact with, I guess this is a family member, Kevin Barlow Jr., and you won't be allowed to go back to the 2750 Eagle Glen Circle without further order of the court. I will allow you to return one time to get some personal belongings, tide you over while this gets sorted out. You can petition your trial court to amend your condition of bond. In 2020 CF 3602, there's two allegations. One is battery on a law enforcement officer and one is resisting an officer without violence. I have reviewed the charging affidavit. I find probable cause for your initial arrest. Bond in that case on count one will be set in the amount of $2,500 and count two in the amount of $500. Thank you, sir.
Your Honor, state would request no alcohol as a condition of
Was
PCR.
alcohol mentioned in the charging affidavit?
Yes, Your Honor.
As a condition of the pretrial release in 2020 MM 2985, Mr. Barlow is not to consume alcohol or possess any illegal substances or consume any illegal substances.
Judge, you're ordering pretrial release on both cases or just the domestic?
Just the misdemeanor.
Yes, Judge.
Thank you. That'll do it for you, Mr. Barlow. Thanks. Fred Hawkins. Good afternoon, Mr. Hawkins. Mr. Hawkins, I understand there is a witness present, so we're going to bring them into the courtroom. All right, as our witness approaches the podium, Mr. Hawkins, I have taken a look at the charging affidavit. In your arrest report, I do find probable cause for your arrest. We have a witness here. Ma'am, we're going to place you under oath.
Do you solemnly swear oath to testify the truth and nothing but the truth, so help you God?
Yes, ma'am.
Ma'am, your name, please?
Veronica Snyder.
All right, thank you. I have found probable cause for Mr. Hawkins' arrest, and I am considering conditions of bond. Do you wish to be heard?
Yes.
All right, when you're ready.
Okay, I don't want to pursue the charges. I was upset, I was scared. Typical argument. We've been together for a while. I do love him. I'm not gonna lie, I'm gonna take him back. Probably gonna bond him out too. So I don't want to pursue the charges. I don't feel like he's a threat to me or nothing like that. At the moment, I was just hot-headed, didn't know what else to do, didn't know what to do, so I just called 911.
All right, thank you. I, as the trial judge or as the IA judge, have no ability to dismiss charges. The charges are brought by the state of Florida. The young lady to your right is an assistant state attorney. I'm sure she's made some notes about your sworn testimony today, and they may be contacting you, or there may be a process for which you can formalize that request from the state of Florida. If the court were allowed to have contact between you and Mr. Hawkins, I would order him to have no hostile contact with you. Do you have a means of communication that you could call law enforcement if you felt like you were in danger in the future?
Yeah, he's allowed, yeah. I'm fine, I'm safe.
Do you and Mr. Hawkins live together?
Yeah.
All right, thank you. If the court considered allowing Mr. Hawkins to return to the home, do you have any fear of violence in the home?
No, that's the only place he can go when he comes home is to me.
Are there any minor children in the home?
No, they stay with my parents.
Thank you. Are you in fear if the court allows contact or allows Mr. Hawkins to come home?
No, I'm not in fear at all.
Thank you. State, any questions of this witness?
Just a few, Your Honor. Has anything like this ever happened before?
Typical arguments, that's about it.
Do you remember telling law enforcement that you had prior instances of physical violence between the two of you?
Yeah, one prior incident.
One prior incident?
Mm-hmm.
Did you call the police at that time?
No,
Why didn't you call police then?
because I hit him too. It was both of us. And it wasn't like he hit me. I hit him and he tried to get me off of him. That's how it happened.
Okay, no further questions, Your Honor.
Ms. Romero-Sanchez, any questions of this witness?
No, Your Honor.
All right. Thank you. Ms. Snyder, you are in the best possible position to gauge whether you believe that you are in danger or not. You have come into court. You have subjected yourself to an examination by both sides and the court. I have no reason to disbelieve what you have told the court, and at your request, under oath, the court is going to allow no hostile contact between you and Mr. Hawkins. Mr. Hawkins, no hostile contact means exactly what it sounds like. I don't care if you guys are having an argument or not. You may not threaten Ms. Snyder. You may not put your hands on her without her permission, and all of the ordinary things that come to mind when I say hostile. Do you understand?
Yes, sir.
All right, thanks. The court will allow you two to cohabitate together. I am going to release Mr. Hawkins on a $100 bond plus pretrial release conditions. Is he on other legal constraints, Mr.?
Judge, he has a detainer for Bay County. There's no bond on that detainer. So he doesn't qualify for a pretrial release.
All right. So you guys won't take him even if the court suggests it?
I know, Judge.
All right, thanks.
Your Honor, just for the record, state would object to no hostile contact and still request no contact just based on the facts that were alleged in the charging affidavit.
Understand. All right, the court's going to, in this case, set bond in the amount of $100 with the special condition that he have no hostile contact with Ms. Snyder, and that will be the sole conditions of bond. Apparently, Mr. Hawkins, you've got another issue down in, or up, I don't know what direction it is, in Bay County that you need to sort out, and that currently has no bond attached to it. So once that gets sorted out, you'll be bondable on our case. We will let Bay County know that you're with us. Thank you.
Question. I can ask a question?
Yes, ma'am?
Okay, so I'm gonna go pay his bond right now, so that way it can move it'll move the process?
You might want to talk to his attorney before you post a bond. And what I'm saying is if a bond is posted, he will be considered released on this offense. There may not be, he may not be eligible for credit for time served that he is in the jail facility. I've appointed the Office of the Public Defender on his case, and you may want to run that decision by them.
Okay, how do I find that out?
If you can just please contact the public defender's office before posting the bond, it can affect him if you post it.
Okay, thank you.
Yes, ma'am. Thanks.
You too.
James Holcomb.
He refused, Your Honor.
All right, thanks. We'll see Mr. Holcomb or give him a try on Monday.
Your Honor, I'm sorry, I didn't hear that. He refused or he's quarantined?
He refused.
Thank you, Your Honor.
So we set it for Monday next month?
I don't want to saddle the,
No, but they have a meeting tonight.
I know. We'll do it on Monday. Court's going to find that the court has made itself available to satisfy his constitutional rights to be seen within 24 hours. He has refused, so we'll see him on Monday. Lefevre Romanovsky. Good afternoon, ma'am. Ma'am, you were arrested based on a allegation in 2020 CF 3605, that being possession of methamphetamine, possession of marijuana, and possession of drug paraphernalia. I have read the charging affidavit. I do find probable cause for that arrest. On that case, you will be granted bonds. Bond in count 1 will be set in the amount of $1,000. And count 2 will be set in the amount of $250, and count 3 in the amount of $500, for a total bond of $1,750. Unfortunately, you are out on bond in 2020 CF 1927. Court finds probable cause to believe that you have violated the law and committed a new law offense while you're out on bond. Your bond in 2020 CF 1927 is revoked. Your bond will be set at none. I will appoint the Office of the Public Defender to represent you on both cases, if not previously appointed in the old case, and certainly on the new case. They can get you in front of Judge Wooten to see if you qualify for a bond. Thank you.
Next court date on demand.
Thanks, Madam Clerk. Charles Matthews. Good afternoon, Mr. Matthews. Mr. Matthews, you have 2 matters before the court. One is the new case, 2020 CT 3278. That is an allegation that you were driving without a valid driver's license. I find probable cause for that allegation. Your bond with us is going to be set in the amount of $500. As to the other issue, it appears that there is an active warrant. From best I could tell, that may be out of Levy County. You have a bond set in the amount of $4,000 in that case, apparently for failing to appear and addressing an earlier citation with them. I'll appoint the Office of the Public Defender to represent you on both cases. Thanks. Amy Plata. Thank you. Good afternoon, Ms. Plata.
Good afternoon.
Ms. Plata, I understand that we have a witness present. While that witness is being located out in the hallway, you have 2 matters before the court. One is 2020 MM2988 and 2020 MM2989. I will appoint the Office of the Public Defender on both cases. Good afternoon, sir. Your name, please?
Miguel Plata.
All right. Thanks, Mr. Plata. We're going to place you under oath.
Do you solemnly swear or affirm to tell the truth and nothing but the truth, so help you God?
I do.
All right. Thank you, Mr. Plata. I believe that you were alleged to be the victim on the original case, which was 2020 MM2660, an allegation of battery domestic violence. Is that correct?
Allegation, yes.
Yes. All right. Thank you. I have found probable cause, which means that I read the charging affidavit and, assuming all the facts are true, which I must at this point, that there is probable cause for Ms. Plata's arrest. It appears that there is currently a no contact order between you two that was ordered by Judge Arendis. Are you aware of that no contact order?
I am aware of it.
All right, thank you. Right. What information do you wish for me to have this afternoon, sir?
I'd like for her to come home. This has been ridiculous. 2 months of not having my wife at home. It's not good for our whole family. We got 3 kids at home, and me trying to control that, and take care of my brother is disabled. My mom. This has been hell. This has destroyed our family, and we need mom in the house. Mom, you guys got to come home, guys.
All right, you understand that the case in which the no contact order has been issued is not before the court. That's on the 2020 MM2660. I understand your thoughts about that no contact order, and perhaps Judge Arendas may revisit that upon the request of her attorney. Ms. Romero Sanchez, is the Office of the Public Defender currently appointed on 2020 MM2660?
I am not certain, Your Honor.
Do we show an attorney on that case? Thank you, Madam Clerk.
Yes, Your Honor, we're actually appointed.
Okay. I'm going to appoint the Office of the Public Defender on the 2 new allegations, 2020 MM2988 and 2020 MM2989. As to count 1 on 2020 MM2988, bond will be set in the amount of $500. As to bond in 2020 MM2989, bond is going to be set in the amount of $500. I'm not going to have any contact provisions on these 2 cases, and I'm not going to have any residence restrictions on these 2 cases. Ms. Plata, you are already prohibited from going to the residence or having contact with Mr. Plata based on the case in 2020 MM2660, which means should you go back there or should you have contact with Mr. Plata, you will find yourself right back before the court. Do you understand? Okay. Till that gets changed, law enforcement can arrest you anytime they feel like it if you are having contact with Mr. Plata or at that property. Do you understand? All right. Thanks. I understand your wishes, Mr. Plata. I can't sort that case out from here. All I can do is address the new cases, which I have done. She's bondable, and that will conclude our hearing today.
See y'all next time.
Thank you.
Judge, you're not taking action on 20 MM2660?
I'm taking no action on 2020 MM2660. Smelly Sucra?
She bonded, Judge.
Thank you. Roxana White Porter Turan.
PD approved.
Good afternoon, Your Honor.
Good afternoon. You are here before the court based on an allegation of driving while license suspended with knowledge. I have reviewed that charging affidavit. I do find probable cause. I will appoint the Office of the Public Defender to represent your interests. Unfortunately, you are out on bond on a DUI in 2020 CT 2048. That case is in front of Judge Jan Savage. Court has probable cause to believe that you were driving while you knew that your driver's license was suspended for that new DUI. In that case, I'm going to revoke your bond in that case. Your bond will be set at none, as I find that to be a danger to the community, and you may petition Judge Jan Savage to reconsider any conditions of bond. I'll appoint the Office of the Public Defender on both of your cases. Does Ms. White Porter Turan have any current court dates with Judge?
December 23rd, if still in jail. January 13th at 8:15 a.m., courtroom 4A, if released.
All right. You'll see the judge on the 23rd, if not before. Thank you.
Your Honor, I'm sorry, did you stay the $500 bond in this case?
Yes, bond in the driving while license suspended case was stayed at $500. PD was appointed, it was revoked in 2020 CT 2048, and she sees Judge Yansevich on the 23rd.
Thank you, Your Honor.
Thank you. Ryan Belknap?
Your Honor, I'd like to waive the reading of the charges.
All right, thank you. Good afternoon, Mr. Belknap. Mr. Belknap, I have a warrant in your case in 2020 CF 3554, and your attorney, which will be appointed in 2020 CF 3554, a representative of the Office of the Public Defender, has indicated to me that you are aware of what those charges are. You do have a bond in that case. The bond is set in the amount of $3,500. Do we have any additional court dates for Mr. Belknap? I don't have any additional court dates for you, Mr. Belknap. Your attorney will be working hard to get you in front of the judge as soon as possible. Thank you. Charlene Krieger.
PD approved.
Good afternoon, Ms. Krieger.
Hello, Your Honor. How are you?
I'm doing okay, thank you. All right. In 2020 CF 3587, you were arrested based on 3 allegations. One is possessing cocaine, one is possessing a controlled substance without a prescription, and one is possessing drug paraphernalia. I do find probable cause for your arrest. You appear to qualify for pretrial release. I am going to release you on pretrial release. Pretrial release folks will get some information from you. I'll appoint the Office of the Public Defender to represent your interests.
Thank you, Your Honor.
Thank you. Good luck, Ms. Craig. Thank you, Madam Clerk. Miguel Garcia Taveras.
PD approved.
Mr. Garcia Taveras, in 2020 CF 3588, there is an allegation of battery on a person 65 years of age or older, aggravated assault with a deadly weapon without the intent to kill, and tampering.
Oh, that's correct.
Your Honor, I do have a probable cause argument in regards to the battery over the age of 65.
All right, thank you. When you're ready, Ms. Romero-Sanchez.
Your Honor, in the allegations or in the affidavit, there's no showing of how old the alleged victim is. Based on that reason alone, we would ask for that. Based on that reason alone, I don't think there's probable cause for at least a battery of a person over 65. I would ask for this to either be reduced down to a battery M1 or our client to be released on his own recognizance in that count.
Thank you. State, Ms. Card.
Your Honor, as state noticed the same issue. We've contacted law enforcement and requested a supplement. Apparently they're preparing it, but they weren't able to provide it to the court in time. We'd ask for a 24-hour reset on this count, or in the alternative to find probable cause for, at a minimum, the misdemeanor battery.
All right, that may not be necessary. Ma'am, your name, please? Do you need an interpreter?
I speak English.
You speak English? Can you tell me your name, please?
Spanish. ¿Eh?
You speak Spanish?
Uh-huh.
Okay.
Hello, Cisco Unity Connect.
All right, apparently all of our interpreters are busy at the moment. We're going to skip over Mr. Garcia Taveras' case. Ma'am, could you have a seat for me and we'll recall you? And I'll recall that case in just a moment. Shadel Tariq Lamar Johnson.
Your Honor, he's a refusal.
Okay. He does not want to go back to Hernando County. He has bonds on 3 counts, $5,000, $5,000, $5,000, and count 4 in the amount of $1,000. We've tried to accommodate his constitutional right to address him within 24 hours of his arrest here in Osceola County. He's ordered to be returned to Hernando County, and it appears from the paperwork that they have been noticed. Thanks.
He's not being reset, Judge.
No. No, we're just going to, he has bond set. I was advising him of the warrant. He's refused twice, so no additional court dates. All right, let me see.
Good afternoon, Your Honor. This is Carlos Morales, State Certified Spanish Court Interpreter, previously sworn.
Good afternoon, Mr. Morales. Mr. Morales, we have Mr. Garcia Taveras, and then we have a witness on that case that will need your services. She's going to be at the podium in courtroom 4F, and she will be outfitted with the equipment in just a moment. I'll let you know when she's outfitted with the equipment.
Thank you.
Mr. Morales, she has the equipment on.
Sí.
We're connected, Your Honor.
Thank you very much, Mr. Morales. Ma'am, we're going to place you under oath. English.
Do you solemnly swear or affirm to tell the truth and nothing but the truth to help you God?
Sí.
Yes.
Ma'am, could you tell me your name, please? You may put your hand down. Thank you.
Virginia Tavares.
Virginia Tavares.
All right. Thank you, Ms. Tavares. Thank you for joining us today. State, do you have any questions of this witness?
Yes, Your Honor. Ms. Tavares, can you tell us your date of birth, please?
20 de junio del 1955.
June 20th, 1955.
And that makes you how old?
65.
65.
Thank you. Any questions from defense?
Yes, Your Honor.
Huh?
Would you wish to have contact with your son?
Sí.
Yes.
And if this was to happen again, or if something was to occur where you're in fear of your life, would you call the police?
Bueno, sí, pero no era de temer.
Well, yes, but that wasn't something to be fearful of.
Are you in fear of your son?
No.
No.
Would you like your son to come back home?
Sí.
Yes.
No further questions, Your Honor.
State, any redirect?
Nothing further, Your Honor. Thank you.
Thank you. All right. If you'll stay with us for just a moment, Ms. Tavares. Mr. Garcia Tavares, I do find probable cause for the allegations of battery on a person 65 years of age or older, aggravated assault without intent to kill with a deadly weapon, and tampering with a witness. You know what? I don't find probable cause for the tampering charge. I don't think it meets the statutory definition. As to that count, you will be ROR'd. As to count one, you are going to be granted a bond. That bond is going to be set at the amount of $1,500. You may have no hostile contact with your mother, Virginia Tavares. You may not return to the 3070 Eagle Crossing address. Do you have personal belongings at that address?
Yes.
Court will allow you to... Yes, ma'am?
Yo vivo ahí, ¿eh? Yo vivo ahí, él también.
Well, I live there, and so does he.
Él no tiene a dónde ir.
He has nowhere to go.
Ma'am, your son's 27 years old. It's alleged that he put his hands on you at the address. I'm not going to allow him to reside at that address until this situation gets sorted out. I will allow him to return one time.
Es que él necesita ir al médico. Él le da todo eso. Todos los años le da esa crisis. Él es bipolar.
Okay. Well, he needs, it's because he needs to go to the doctor. That happens to him every year. He's bipolar.
Are there children in the home?
En un hospital. Sí, dos.
Yes, 2.
What are their ages?
11 y 7.
11 and 7.
Do you have any family members that live in Kissimmee?
Otra hija mía, sí.
Another daughter of mine, yes.
Right. Until this situation stabilizes, I'm not going to allow him to return to the house at 3070 Eagle Crossing. He can return one time with law enforcement to get some personal belongings. The family can petition the trial judge to consider reasonable conditions of bond or a change to the reasonable conditions of bond in the future. But at this point, he's not to return. You may have no hostile contact with him. And I will appoint the Office of the Public Defender to represent his interests.
Your Honor, I actually didn't get the second count.
Se va a quedar preso entonces.
So he's going to remain in jail then?
No, ma'am. He's been granted a bond. He can get out of jail if he posts the bond. He can even have contact with you as long as that contact is non-hostile
Pero
contact.
yo no tengo dinero para pagar esa fianza. Yo no tengo dinero para pagar esa fianza.
But I don't have any money to pay that bond.
Oh my God, es complicado.
You may talk to family members but a bond is appropriate based on the allegations in the charging affidavit.
Your Honor, do we have a bond for count 2?
Y si no se paga, él no sale entonces.
So if that's not paid, then he can't get out?
That is correct, ma'am. I'm going to amend the bond to $1,000 is to count 1 and $500 is to count 2. With those special conditions as previously announced.
Oh, Señor Jesús. Oh, Dios.
And I have appointed the Office of the Public Defender to represent Mr. Garcia Tavares. Thank you, ma'am.
Yo solamente quería que él fuera al hospital, más nada.
All he wanted was for him to go to the hospital, nothing else.
Ya veo que no se puede usar la policía para nada.
I know this is a complicated family situation, and it may not be something that I can sort out today. He is able to be bonded out of jail and have no hostile contact with you. Mr. Garcia Tavares, your interactions with your mother must be not hostile, meaning you can't scream at her, you can't put your hands on her without her permission. Do you understand?
Your Honor, he walked back. Would you like him to report again?
Nope, that information, no hostile contact will be on his paperwork.
Yes, sir.
Do you think he is allowed to return or not?
Not allowed to return, he's allowed to have no hostile contact with his mother. Thank you. All right. Ma'am, we will generate some paperwork with the court's ruling.
Okay.
Thank you, ma'am. That will complete our hearing.
Your Honor, may the interpreter get the case number, please?
Yes, of course. That is 2020 CF 3588.
Okay, thank you.
Ms. Romero Sanchez, do you have any additional clients that have yet to be seen?
No, Your Honor.
Thank you. That will complete our hearing today.
Thank you, Your Honor.
Today is not the day to have that discussion. It's very unlikely. I'm your trial judge. So you need to save that discussion for your attorney and your trial judge when the time comes. I'm going to talk about getting an attorney on board for you. And then after that, we'll talk about conditions of bond that may be appropriate to get you back to your lives while your cases are pending. The first case that I have is an interpreter case. Urbana Lopez. Hold on for a sec, Deputy. We may not have an interpreter.
Good afternoon, Your Honor. This is Theodore Leal, Spanish interpreter. The interpreter has been previously sworn, Your Honor.
Good afternoon, Mr. Leal. We have Mr. Urbina Lopez at the jail facility. You'll be doing your interpreting over the intercom system. The case number is 2020 MM2981.
Thank you, Your Honor.
Good afternoon, sir.
Buenas tardes, señor.
I speak English.
You speak English. Okay, we had you as an interpreter case. Let's ask our witness. Good afternoon, ma'am.
Buenas tardes, señora.
Do you need the assistance of an interpreter?
¿Usted necesita la ayuda de un intérprete?
Not for English, no, I'm okay.
No? Okay. And Mr. Urbina Lopez has indicated, sir, you don't need the interpreter?
No, I don't.
All right. Mr. Leal, I think that's all the business we have for you.
Very well, Your Honor.
Thank you for joining us.
Sure thing, Your Honor.
Thank you. Mr. Urbina Lopez, you were arrested based on an allegation of battery, domestic violence related. I took a look at the charging affidavit. I do find probable cause for your initial arrest. We do have a witness present, and I'm going to take some testimony, ma'am, from you. I'm going to swear you in first.
Do you solemnly swear or affirm to testify the truth and nothing but the truth, so help you God?
Yes.
Ma'am, your name, please?
Chelsea Insel?
Thank you, Ms. Insel. And you are you the daughter of Mr. Urbina?
Granddaughter.
Granddaughter? All right, thank you. And what information would you like me to have?
I guess what happened?
All right. Today is the day where I'm determining whether there is probable cause for Mr. Urbina Lopez's initial arrest. I've already found that. I will be considering whether the court will be allowing contact between your grandfather and you. Do you live at the home on Juliana Court?
Yes.
All right. All right. Do you have any children that live there?
My little brother lives there, but he's
Little
not.
brother? Okay, thank you. And your grandmother lives there?
Yes.
Anybody else in the home?
My mother and my stepfather.
All right. Thank you. All right, and you are alleged to be the victim in this case. Do you wish to have contact with your grandfather?
No.
All right, thank you. Are you in fear if Mr. Urbina Lopez is allowed to come back to the home that there will be further incidents of violence? How long have you lived at that home?
On and off for, I want to say maybe 3 to 4 years.
All right.
We lived in before together, but then I moved out and then I came back. And
Right, thank you. Have there been previous incidents of violence?
No.
Mr. Johnson, do you have any questions of Ms. Insel?
No, Your Honor, not.
State, any questions of Ms. Insel?
I didn't see anything in the report about it, but were alcohol or drugs or anything like that a contributing factor in this case?
No.
No, okay. Thank you. I don't have any other questions.
All right, thank you. At this point, I am going to set bond in the amount of $500 with pretrial release conditions. Those conditions are to be that the defendant may not have contact with the alleged victim, Ms. Insel. He may not return to the location of the home, which is 2204 Juliana Court. I will allow him to return one time to get some personal belongings So while this case is pending, and I will appoint the Office of the Public Defender to represent his interests.
Your Honor, in DV cases, the state always asks for no weapons, no firearms while on release.
I think that's a standard condition of bond, but yes, Mr. Urbina Lopez may not possess any firearms or weapons as a condition of his bond.
Thank you, Your Honor. And the one-time return, is that with law enforcement?
That is correct.
Thank you, Judge.
Yep, he'll have to have law enforcement present when he returns to get some personal belongings. Thank you. Thank you for being present. Reginald Johnson.
We're calling the name, we don't see the person yet. Not sure what's going on.
Okay, do we have two separate groups today, corrections?
So it sounds like we have one group, Judge. We're just trying to track down what happened with Johnson. They thought we had her.
Okay, no problem. I'll skip over Mr. Johnson's case, and his name is Shadel, S-H-A-D-E-L Johnson.
Thank you, Judge.
Thanks. Mahed Al-Timi. Sir Al-Timi, good afternoon.
Excuse me, sir?
Good afternoon. Your name, please? Tell me your name, please.
Majid Al-Tamimi.
Thank you, Mr. Al-Timi. Mr. Al-Timi, you were arrested based on an out-of-county, it was an active warrant out of Osceola County. It's our warrant, cases 2018 CT 399. It alleges failing to appear on a driving charge in front of Judge Yansevich. Judge Yansevich did issue a bond on your case in the amount of $2,000, and I will appoint the Office of the Public Defender to represent you on that case if they weren't previously appointed.
And Judge, on behalf of Mr. Al-Timi, we'd be asking if we could potentially lower this bond today. This is from 2018 for the no valid driver's license, and checking DMV website earlier today, it looks like he does now have a valid driver's license since that 2018 date. And also he has substantial amount of family members in the area and would not be able to post a $2,000 bond in this case.
All right. Judge Yansevich was in the best position to consider the amount of bond. I'm not going to reduce her bond amount without having Mr. Al-Timi appear in front of her, so it will remain at $2,000.
Yes, Judge.
Thank you. Wendy Cosper. Good afternoon, Ms. Cosper. Ms. Cosper, you were arrested based on a bench warrant. The allegation was driving while license suspended. Judge Epperson issued a warrant for you, did grant a bond in the amount of $5,000, indicated that you failed to appear for a plea date in 2020 CT 650. Mr. Johnson, was Ms. Cosper already a client of the Public Defender's Office?
Yes, Your Honor.
All right. So their appointment will continue. You have a bond on this case. And do we have any dates in front of Judge Yansevich?
Judge, since this was set for a plea date previously, if we could try and keep that set for a sooner court date, if possible.
Yeah, I don't think we have access to Judge Yansevich's calendar. If you can talk to your colleague who has this case, perhaps they can call her judicial assistant and get it on in an expedited fashion.
Yes, Your Honor.
Thank you.
Thank you, Judge.
Desiree Kotuch, or
President in person, Your Honor.
thanks. Good afternoon, ma'am. Would you pronounce your last name for me?
Katuch.
Katuch. Ms. Katuch, you were arrested based on an allegation that you failed to appear for a violation of probation arraignment on case number 2019 CT 4365. That warrant was issued way back in August. Judge Arendis has issued no bond. You're going to remain on no bond until you can get in front of her and I will appoint the Office of the Public Defender to help you with that. Do we have any dates? We have some dates for you, Ms. Katuch.
Next court date, December 17th at 8:05.
All right, you've already got a court date for December 17th.
Thank you, Your Honor.
Thanks. Patrick Lowell. Good afternoon, Mr. Lowell. Mr. Lowell, you were arrested on my warrant in 2019 CF 3576. The allegations are that you violated probation in that case with allegations of a violation of Condition 3, absconding, and your unsuccessful discharge from the program. I issued no bond. You're going to remain on no bond, and I'll see if I've got you set for a violation of probation status date.
He's on for December 16th at 8:30.
All right, we've already got you on for a violation of probation status date of December 16th, which is next Wednesday. We'll see you then.
Thank you, Judge.
Thanks. Nathaniel Solomon.
Video approved?
Approaching, Your Honor.
Good afternoon, Mr. Solomon. Can you hear me okay?
Yes, sir.
All right, thanks. Mr. Solomon, you were arrested based on an allegation of failing to appear for arraignment on a attaching tag to on a vehicle that was not assigned. Judge Yansevich issued the warrant back on September 14th. She did grant you a bond in the amount of $2,000, and I will appoint the Office of the Public Defender to represent your interest on this case.
Thank you, Judge.
Thanks. Tia Tanner.
Video approved?
Good afternoon, Ms. Tanner.
Good afternoon.
Ms. Tanner, you were originally arrested on an allegation of home invasion with a firearm, aggravated assault with a deadly weapon, and grand theft. Since then, the state of Florida has filed a 13-count information. I'm going to read off those counts, and then I'll assign a bond for each of the counts. Count 1 is burglary of a dwelling with an assault or battery with a firearm. Count 2 is robbery with a firearm. Count 3 is robbery with a firearm. Count 4 is robbery with a firearm. Count 5 is robbery with a firearm. Count 6 is robbery with a firearm. Count 7 is aggravated assault with a deadly weapon. Count 8 is aggravated assault with a deadly weapon. Count 9 is aggravated assault with a deadly weapon. Count 10 is aggravated assault with a deadly weapon. Count 11 is aggravated assault with a deadly weapon. Count 12 is conspiracy to commit robbery with a deadly weapon. And count 13 is conspiracy to commit robbery of a dwelling. Judge has already found probable cause for those allegations for something alleged to have happened back on June 26, 2020. State, in the filing of the information, did judges assign bonds for the new case, for the new counts?
Your Honor, I don't believe that bonds have been assigned for any of the new counts. I will note that the count 1 on the information is a life felony, and the state would be asking for no bond as to count 1.
Judge, at this time, I'd be asking if we could reset. As of right now, the only thing I have on behalf of Ms. Tanner's case is simply the booking report that says she was picked up on a warrant. We don't have said warrant, and I'm not prepared for a proof evident presumption great hearing at this time. Additionally, the public defenders have previously withdrawn due to a conflict in Ms. Tanner's case, and so we'd be asking if you're going to appoint counsel today, if we could appoint RCC.
All right, thanks. The court is going to appoint the Officer of Regional Conflict. I think she was picked up in Orange County. She's been there for quite a while, and we're just now getting the transport effectuated so she can have her first appearance with us. Bond in count 1 is going to remain at no bond. I am going to give bonds on the remaining counts. As to count 2, bond will be set in the amount of $5,000, 3, $5,000, 4, $5,000, 5, $5,000, 6, $5,000, 7, $1,000, 8, $1,000, 9, $1,000, 10, $1,000, 11, $1,000, 12, $500, 13, $500. We'll appoint Officer of Regional Conflict, make them aware of your no bond status, Ms. Tanner, on count 1, and they can bring you before your trial court to see if you qualify or the state will consider a bond in your case. Do we have any additional court dates for him?
Yes, December 21st, for Raymond, at 8:15.
All right.
Your Honor, I'm seeing Jonathan Mills in our case management system as representing her. Just before we assign the Office of Regional Conflict Counsel.
And I think it was because I think he was appointed as conflict counsel.
Okay.
Yeah.
Okay, so we don't need to appoint RCC. She's already got Mr. Mills?
If we could just double check that. I believe so, but
Madam Clerk, who are we showing as the attorney of record?
Mills.
Yeah, I see J. Edwin Mills. I believe that's senior. Experienced trial attorney, and Mr. Mills will remain on as the attorney of record. We'll notify Mr. Mills of today's hearing.
thank you.
Thanks, Mr. Tanner. Michael Emery. Thanks. Good afternoon, Mr. Emery. Mr. Emery, I think you may be in a similar circumstance. I saw that you were in jail in Orange County and you're just now getting over to us. Judge Morgan issued a no bond warrant for an allegation of violating your probation in 1998, CF 1278, the allegations being a violation of Condition 7 and a violation of Condition 1. I'm going to appoint the Office of the Public Defender if they weren't previously appointed, and we may have a date for you.
Next court date, December 21st, at 8:15 a.m.
You'll see Judge Morgan on the 21st.
21st, got it.
Thanks.
Thank you.
Patrick Alexander. Good afternoon, Mr. Alexander. Mr. Alexander, you were arrested based on an allegation of purchase of a synthetic narcotic. I read the charging affidavit. I do find probable cause for your arrest. You qualify for pretrial release. You are going to be released on straight pretrial release, and I'll appoint the Office of the Public Defender to represent you. PTR will come out and get some information from you prior to your release, okay? Do we have any additional court dates on demand?
On demand.
Thanks.
Were there any additional court dates, Judge?
No, on demand.
Okay, thank you, Judge.
Thanks. Anthony Bucci.
And Mr. Bucci is present and approaching. If we could first address the public defender so that way I could talk a little bit more about this.
All right, thank you. I was inclined to appoint the Public Defender's Office on behalf of Mr. Bucci. Is there a conflict?
It's not a conflict, Judge. Today we'd be asking for the court to take judicial notice of the record in 19 CF 3238. Mr. Bucci has previously been found incompetent to proceed. And when I was looking through the case, I didn't see a subsequent written order finding that he was competent, although there was, it looks like a plea. Digging through the report, I see that Dr. Duros has previously opined that there's mental health at issue, including potential for a TBI here, Your Honor. So I'd be asking if we could potentially ROR Mr. Bucci.
All right, I'm going to formally appoint the Office of the Public Defender to represent his interests in 2020 MM 2978. The allegation is an allegation of trespass at the Sunoco. I note for the record he's already out on bond, or excuse me, ROR for a trespass at the Wawa. Not inclined to ROR Mr. Bucci. I will set bond the amount of $100 with a condition of bond that he's not to return to the Sunoco or the Wawa. and the Public Defender's Office has been previously appointed. If upon your discussions with Mr. Bucci, you think that there may be a competency issue, please have you or your colleague file that with the trial court.
Thank you, Judge.
Thanks.
Judge, are you taking action on the 20MM 2814?
I am not taking action on the case that he's out on bond in 20MM 2814.
Thank you, Judge.
Scott Clemmer.
President approaching, Your Honor.
Good afternoon, Mr. Clemmer. Can you hear me? All right, thanks. I was having a hard time hearing you. You were arrested in 2020 MM 2979 for an allegation of battery. Took a look at the charging affidavit. I do find probable cause. You meet criteria for release on pretrial release. You will be released on pretrial.
I'm sorry, Your Honor?
Yes.
Reading over the charging affidavit here, I understand that he was not arrested for it, but the facts described herein describe a burglary of a conveyance with a battery therein, not just an M1 battery, but an F1 PBL. Before he's released on straight PTR, would ask the court whether the court believes that there is probable cause for that higher charge and whether it impacts his conditions of release in your mind.
All right, the allegations in the charging affidavit are that there was a physical altercation and that the defendant followed.
Your Honor, I can direct the court's attention if that's easier.
I'm seeing it on page, in the second paragraph, page 1.
That's right, Judge.
Yep, thanks.
And Judge, just for the record, there was no mention of the punishable by life charge in the original booking affidavit. The officer did not indicate that in the booking affidavit. And for the record, it also looks like that this also, the arrest location and the violation, alleged violation location are also Mr. Clemmer's permanent address.
Right, yeah, that's my understanding. The law enforcement officer who was there took statements from everyone and probably had the best contemporaneous observations of the facts, chose to arrest on the offense of misdemeanor battery. If the state feels that there is a more egregious crime that is warranted, they may file that by information. At this point, I'm not going to make a probable cause determination as to any uncharged offenses. The court's going to release Mr. Clemmer on pretrial release with the special conditions that he not have any contact with Brandon Clark, that he not possess or consume any alcohol, he not possess or consume any illegal substances. And those will be the conditions of his pretrial release.
Judge, no weapons, no firearms?
He's not to possess any weapons or firearms as a standard condition of pretrial release. So, Mr. Clemmer, if you got some stuff at the house, that needs to go to a neighbor or family member. Okay. Thanks.
Thank you, Judge.
Tyler Clement.
President approaching.
Thanks. Afternoon, Mr. Clement. Is it Clement or Clement? Clement. Mr. Clement, you were arrested based on an allegation of possessing a controlled substance without a prescription, possessing cocaine, possessing another controlled substance without prescription, and possessing drug paraphernalia.
Your Honor, I believe there was a scrivener's error on count 2 in this case. It appears that he was arrested for possession of cocaine. The field tests indicate that that should have been morphine, though. Methamphetamine, morphine, and heroin, as opposed to meth, cocaine, and heroin.
Yeah, although in the offenses charged, it references cocaine, and in the sworn affidavit portion of the document, it does indicate the specific substances of methamphetamine, heroin, and morphine. Court's going to set bonds in these cases. As to count 1, bond will be set in the amount of $1,000, count 2 in the amount of $1,000, count 3 in the amount of $1,000, count 4 in the amount of $500. Officer Kendo, it indicates that Mr. Clement does not qualify for pretrial release. Why is that?
Judge, the defendant is out on pretrial diversion for Lake County, charges of possession of drug paraphernalia, possession of marijuana, carrying a concealed weapon, improper exhibition of a weapon.
Okay. All right, as a condition of his bonds, he's not to possess or consume any illegal substances. He's not to possess any weapons or firearms. Any other requested terms of bond requested by the state? Thanks. And I'll appoint the Office of the Public Defender to represent your interests, Mr. Clement.
Thank you, Judge. And just for clarification's sake, on the last case with Scott Clemmer, was the PD appointed on that case? I didn't catch it.
I just appointed you.
Okay, I meant on the one before, Mr. Clemmer, not Clement.
Oh, sorry.
Yep, sorry. Another question.
Did he qualify, Mr. Clement?
Yes.
I'll appoint the Office of the Public Defender on Mr. Clemmer's case as well.
Thank
Sorry,
you.
sorry, Mr. Johnson. Charlene Krieger.
We're trying to track down Charlene Krieger, Your Honor. Oh, she's in. Judge, we're tracking it down. It sounds like she may be in medical right now.
Okay, Charlene Krieger, and we'll recall her at the end of the docket. Miguel Garcia Taveras.
Oh, looks like, Judge, it looks like they're resetting him today. They weren't able to get him here.
For what reason?
It sounds like he may have refused, Your Honor.
Okay. All right, we'll reset him to tomorrow. He had a witness present, but we will inform that witness that his hearing is not moving forward. Thanks.
Thank you, Judge.
Gene Gomes. Gene Gomes.
President approaching, Judge, sorry.
Thanks. Hello again, Mr. Gomes. Mr. Gomes, you have 2 issues before the court. The first is 20 CF 3031. We're going to talk about that one in a minute. The next issue that you have is 2020 CF 3589. 2020 CF 3589 alleges a number of counts, sale of synthetic narcotics within 1,000 feet of a specified area. That is a first-degree felony allegation. Possessing cocaine, possessing drug paraphernalia, and
Delivery of drug paraphernalia.
delivery of drug paraphernalia. Bond in count 1 will be set in the amount of $10,000, as to count 2 in the amount of $1,000, and count 3 in the amount of $1,000, and count 4 in the amount of $500. I do find probable cause for those allegations. Court had issued a warrant for your arrest. I had initially set a bond for you, Mr. Gomes, in 2020 CF 3031. I have probable cause to believe that you have committed a new felony law offense while out on bond on that case. Your bond in that case is going to be revoked, and your bond will be set at none. And I will appoint the Office of the Public Defender to represent your interests on both cases. Thanks. Tiffany Jackson.
President approaching, Your Honor.
Thanks. Good afternoon, Ms. Jackson. Ms. Jackson, you were arrested based on an allegation of battery, domestic violence related. I took a look at the charging affidavit. Do find probable cause for your initial arrest. You're going to set a bond in your case in the amount of $500. You're to have no contact whatsoever with Maurice Jackson, who I guess is your brother. You're not going to return to the 875 Chamberlain. I'm sorry, you're going to maintain separate residences from Mr. Jackson. Yeah, you don't live at the house on Chamberlain, do you?
No, my kids is
I'm sorry, I didn't hear you.
I said no, but my kids is there.
Your kids are there?
Yeah.
All right. The order's going to be that you and your brother Maurice need to maintain separate residences. You're not allowed to have contact with Maurice, so if the kids are over there, you can't be over there while he's there. And I'll appoint the Office of the Public Defender to represent your interests.
Thank you, Judge.
Do you have personal belongings over at that place?
Yes.
I'll allow you to return one time with law enforcement so you can get some stuff while this gets sorted out. Thank you.
And Judge, just for the record, jumping back to Charlene Krieger, if we'd be asking if we could reset this case. It sounds like she's in detox, Your Honor. Or he or she is in detox.
All right, we'll set Ms. Krieger's case for tomorrow.
Thank you, Judge.
Thanks. Oscar Rivera. Good afternoon, Mr. Rivera. Mr. Rivera, you were arrested based on 2 allegations: possessing a controlled substance and resisting an officer without violence. Took a look at the affidavit, and based on assuming that those facts are true, there is probable cause for your initial arrest. Mr. Officer Akendo, he qualifies for pretrial release?
He does, Judge.
All right. Court's going to release you to pretrial release. As a standard condition of pretrial release, you are not to possess any weapons or firearms. You're not to possess any illegal substances. And you'll be randomly tested for any drugs in your system.
Yes, sir.
All right. Thanks.
Thank you.
Fernando Taylor.
Taylor's President approaching, Your Honor.
Thanks. Good afternoon, Mr. Taylor. Mr. Taylor, you were arrested based on an allegation of possessing cocaine and possessing marijuana on December 9th. I took a look at the charging affidavit. I do find probable cause for that initial arrest. I'm going to set bonds in that case. Count 1 in the amount of $1,000 and count 2 in the amount of $250. Fortunately, you were out on bond on 2020 CF 2167 and that's with me, and 2020 CF 6376, that's in Orange County. I'm going to revoke your bonds in those cases. I have probable cause to believe that you committed a new felony offense while you're out on ROR on our case and ROR on an Orange County case.
Oh, that's closed in Orange County.
20 CF 6376, Officer Akendo, are we showing that that's closed out?
We're showing that it's open, Judge.
I'm going to appoint the Office of the Public Defender on all 3 of these cases. Mr. Taylor, have a conversation off the record with Mr. Johnson. Tell me what's going on 2020 CF 6376.
Has trial coming up in January 11 of 2021 with Judge Calderon.
Mr. Johnson, we're showing that that case is still set for trial in front of Judge Calderon in January.
Okay, Your Honor. Then in that case, we'll get in touch with Orange
Okay.
County Public Defender.
Mr. Taylor, we'll try and sort that case out for you. On my case, I'm going to revoke your bond because I got probable cause to believe you committed a felony while you were out on my ROR. So your ROR is revoked in that case. I'm not going to set bond. Your bond is set at none. At this point, Mr. Johnson's aware of your issue, and perhaps he can get you in front of me and we can have a more detailed discussion about that another day. Thanks. No, they're both, I'm revoking ROR in both cases. Bond is set at none in both cases. Ryan Belknap?
Judge, if I can see, we'll try and track him down.
Thanks. 2 cases I have remaining are Reginald Johnson and Ryan Belknap.
Judge, it sounds like if we could reset this case, it sounds like he may be in detox and also self-harm, Your Honor.
All right, thanks. Mr. Belknap, we'll try again tomorrow on Mr. Belknap's case.
Thank you, Judge.
Thanks. And Mr. Johnson, when you have an update for me on Reginald Johnson, let me know.
That case similar situation, but it was a refusal in that case, Your Honor.
Okay. All right, we'll try again with Mr. Johnson tomorrow.
Thank you, Judge.
That was the last case I had on my docket. Do you have any other folks that?
I think we addressed everybody over here, Judge.
All right. Thanks, y'all.
Thank you, Your Honor.
We'll be in recess. Thank you for your help, Mr. Kazar.
Thank you very much, Judge. Always a pleasure.
Likewise.